My name is Christopher Iannella. I'm here the hearing today. At this point, I would like to read a letter addressed to the councilors. Dear councilors, I'm pleased to nominate Connor M. Barouch to the position of Associate Justice of the Boston Municipal Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Maura T. Healy, Governor. At this point, good morning, how are you? I'll hear from your witnesses. First witness, the Honorable Peter Krupp, Associate Justice of the Suffolk Superior Court. Good morning, you can stand or sit, whatever's easier for you.
Sit, that's okay.
Good.
Good morning, councilors. My name is Peter Krupp. I have served as a Superior Court judge for almost 12 years, and it's my honor and privilege to speak on behalf of the nomination of Connor Barouch to the position of Associate Justice of the Boston Municipal Court. And let me say it would be my pleasure to speak on his behalf again in 5 years if he decides that he would like to join the Superior Court. Few people have the ability, confidence, and quiet presence to walk into a courtroom and control the space, not in an overbearing way, but in the sense that everyone in the courtroom knows that they're in the presence of a great lawyer who is comfortable in the courtroom, confident in himself, and thoroughly prepared. Attorney Barouch is one of those few people, and all the more remarkable for a lawyer under 40 years old. He will make a terrific judge. I've known Attorney Barouch for at least 7 years in a professional capacity. Attorney Barouch tried 3 cases that I can remember before me in the Suffolk Superior Court. He tried an assault and battery with a dangerous weapon and firearm case in 2017 with a split verdict. He tried a rape case in 2018 in an early case using panel voir dire and tried it to a hung jury. And in one of the first cases tried after we effectively closed down trials due to COVID-19, in May of 2021, he tried an aggravated rape case with impanelment in the Suffolk courthouse and with a very awkward and socially distanced trial held in the federal Moakley courthouse. In those cases, I saw an attorney who was whip smart, always prepared, and calmly and creatively able to handle the unpredictable. Attorney Barouch is the kind of lawyer that juries sit up to listen to more carefully when they stand up to start the examination of a witness. And for those of you who have tried cases, you know that is really hard to achieve. Equally as important, in the cases that Attorney Barouch tried before me, in addition to a lawyer who was incredibly effective for his clients, I saw a lawyer who was aware of the trauma of the people in the courtroom, who understood how daunting the courtroom could be for the people who were witnesses or parties, and who could sensitively cross-examine an alleged victim without antagonizing or alienating the victim or the jury, and without sacrificing the zealous advocacy for his client. It was not surprising at all to me that over the last 5 or 6 years, CPCS has asked Attorney Barouch to take on a role, among other things, of training and mentoring other lawyers. Attorney Barouch would bring these skills, his life experience, his wisdom and sensitivity, and his deep understanding of the trial process to the bench. Judge Barouch would care deeply about the people who would appear before him and would bring to the role his considerable intellect and insightful wisdom about people. I couldn't recommend Attorney Barouch more highly for the position as an Associate Justice of the Boston Municipal Court. I'd be happy to entertain any questions that the council has.
Thank you very much, Judge. Any questions from the councilors? There being none, thank you very much for your testimony. Next, we'll hear from Attorney Christina Rodriguez, Committee for Public Counsel Services. Good morning.
Morning. Good morning again. My name's Christina Rodriguez. I work as a supervisor at the Committee for Public Counsel Services. In my role, I help manage the organization's Roxbury office, supervising attorneys there, carrying my own Superior Court caseload, and taking a leading role in building community partnerships. I started at CPCS 8 years ago, and that was when I first met Attorney Connor Barouch. who has now been my close coworker and premier mentor for nearly a decade. I endorse Attorney Barouch for this nomination without reservation and with the greatest enthusiasm. He's a person of exceptional integrity. One of the first opportunities that Attorney Barouch and I had to meaningfully interact was when he invited me, as a very new attorney, to join him on a trial. I learned so much from watching Attorney Barouch in action. He studied the law, he knew cases inside and out, he understood our state courts and he was comfortable in them. He was masterful at each piece of the trial: jury selection, opening, witness examination, jury instructions, closing arguments. He understood those not just as technical parts. He understood how they came together, that the pieces of litigation had been chiseled by thinkers and advocates who preceded us, that they could be brought together in service of a greater good, in service of the principles that animate our legal system, so that the goal that every side, every person, and every story can be heard in our courtrooms. Attorney Barouch believes and practices that. He is one of those consummate professionals who brings to life the best of our legal tradition, the best of our jurisprudence, while gracefully moving it forward. He does that work in moments big and small, and he does it not for recognition, but out of a sense of duty to the collective, a sense of belonging to our collective community. He moves thoughtfully, carefully, calmly, compassionately, humbly, and lawfully. In trials we did together, in trainings he has run all over the state, for many, many defense attorneys, I've had the opportunity to see how Attorney Barouch treats the people around, all of the people around, across difference in identity, in title, in role, in perspective. Respect, inclusivity, kindness, individualized consideration, and active listening are instincts for Attorney Barouch. He truly sees everyone in a room and welcomes them into the conversation. I've personally seen him maintain composure and professionalism under a wide range of circumstances, from client emergencies to impossible caseloads and schedules. He's been professional, measured, careful to collect information before making any significant decision. Neither wins nor losses changed his character. When he won, he didn't gloat, and when he lost, he did it gracefully. Challenges he raised were within proper channels, within the rule of law, and contributed to the development of our jurisprudence. He always understood and taught that this work ultimately wasn't about him. It wasn't about stacking wins. It was about contributing to the local community, to the best of the legal profession, to the project of justice. In closing, I'd like to thank you all for your work and for allowing me to speak today on behalf of a tremendous human.
Thank you very much, Attorney Rodriguez. Any questions from for Attorney Rodriguez? Counselor Jacobs.
Not a question. I just wanted to say I very much appreciate the service that you provide, and I'm always happy to hear from members of CPCS when they come forward. So just thank you.
Thank you.
Thank you very much. Have a nice day.
Thank you.
Before we hear from the nominee, I'd like to introduce the other members of all the councilors. To my left here, Counselor Eunice Ziegler, Counselor Paul DiPaolo, Counselor Tara Jacobs, Counselor Tamisha Civil, Counselor Mara Dolan. And as you know, my name is Christopher Iannella. At this point, before we hear from you, I know you have a lot of distinguished people here and friends and family. So if you'd like to introduce them, that would be fine.
Sure. A lot of people actually are surprised. Justice Henry is here. Judge Green from the Boston Municipal Court. Rachel Cully from the Department of Labor. Kat Rusnak, who's my partner. Christina Rodriguez and Judge Krupp already. Judge Lisa Grant, also from the Boston Municipal Court. These are my parents, Ron and Cynthia. And they came all the way from Virginia here today. And my sister, Julia, who's a teacher in Somerville schools. My supervisor, Melissa Deneen, who runs the training department at CPCS. Emily Cardy, also an appeals attorney and trainer. And welcome to the folks who I don't know as well. Thank you. And Josh Cohen from CPCS, and of course, I think, oh, and Denise Regan, who's always small in stature, but a well-known defense attorney. And I think the rest of the room, you all likely know.
You have a lot of supporters.
Yeah.
Okay, and now we'll hear from you.
I want to start by thanking Governor Maura Healey and Lieutenant Governor Kim Driscoll for nominating me, and Paige Scott Reed and Derek Kesselheim for their help and wisdom in the process. Without them, I literally would not have made it through this process. So thank you very much. Kimberly Baptiste for keeping everything organized and being a great communicator, and Valerie McCarthy for her logistical work, even while I know she was busy onboarding several new governor's counselors. I also most relevantly want to thank each of you on the Governor's Council, whether you're brand new and this is your first hearing, or whether you've been doing this for a really long time or something in between. I want to thank you for all the time that you've spent getting to know me, reading, I know, the voluminous applications that you read, but really overall creating a process that appoints a bench of qualified judges. I really appreciate the time you put into this project. You heard a little bit about the people who are here supporting me, and I just want to thank each of them for being here, and particularly my parents for coming from far away, my partner Kat, who has supported me throughout this process in these last few years, my ex-husband Greg, who's not here but who's been extremely supportive through law school and my legal career, even now trading custody days with our dog to match my trial schedule. And my sister Julia, who's here, as well as my brother, who's online. If he has a break at Trader Joe's, hopefully he does. So thank you. And to the many mentors and attorneys who've supported me, whether you're in this room or not, I really appreciate it. To tell you a little bit about myself, I moved to Massachusetts when I was 17 and I never left. I was raised in a way that made me flexible, getting used to new places and getting to know new people. My mom was a military brat and moved around. And so she had lived both here in Massachusetts and in Virginia. She and her parents settled in Virginia, but a couple of my aunts and their families were settled up here. So it wasn't an unfamiliar place. Their family is particularly proud to be Swedish and to show off Swedish food. We just had Swedish Christmas, and celebrating every occasion by saying skål, something very Swedish. And they moved around with her dad's Navy career until she settled in Virginia, which is where I grew up. My dad is from California, of Jewish descent, and their family is proud to have been involved in school integration in the 60s. So it was sort of a mixture of two different families. And I think that mixture helped me feel like I could fit in a room with people from anywhere, whether they had the same traditions or customs or religions as each other. That helped me get adjusted to being a young person who could go to lots of different schools and move lots of different places. I went to a couple of different elementary schools in Virginia. I moved when my brother needed to go to a different school, and then I started middle school there. And then my family up and moved to Australia, where I started middle school. And I was a new kid in the school again, this time in a new country, where I didn't really know anything about how things worked. But I quickly got used to it. I was really a math and science nerd kind of kid, and I got really interested in my math and science classes and studies and doing extra math and science outside of class, playing board games. You can just imagine the little nerd that I was. But while I was in Australia, I also got really interested in the outdoors and became a hiker. I joined the Scouts there. I liked hiking, backpacking, camping, all of those kinds of things. And I still have that outdoor-indoor combination today. I love to take a weekend in Western Mass or New Hampshire to go hiking. And I still work as a camp counselor on some weekends within my trial schedule and my training schedule. So that outdoor indoor guy thing is still a big part of my life. During high school, I moved back to Virginia and I'm a new person in a new place once again. But this time I was in a familiar country, although being a sophomore in high school, in a school where you don't know anyone, is still quite an experience. But I built community and made friends, returning back to my passions for math, science, board games, and joining scouts and helping take younger kids camping and stuff like that. By college, I was spending my weeks with my math study group and my weekends with my friends that led backpacking trips. And I started to, at that time, realize that, while I was in high school, I realized my gender wasn't quite what everyone else's seemed to be. And by college, I started to put language to it and put words to it. But I also realized that some of my friends who were transgender were fundraising for, advocating for. It's really hard to get any kind of medical procedures at the time, but they were fighting for medical procedures that I didn't really need myself. So I wondered if I wasn't as transgender enough to be a part of the community. But I still stayed involved. And then on an internship as a public defender investigator in DC, I discovered my passion for the law. I met people who are my age who were either accused of really serious crimes, who either experienced violence or had witnessed it. And I started to see the intricacies of how a legal system could either help reduce or worsen the harm in those kinds of situations. As I looked around the work I was doing and the system I was working in, there were enough homophobic and transphobic comments that I wasn't sure I could be both openly trans and work as a public defender. Still, I decided to go to law school because I was just that interested in doing the work. And after law school, I clerked and I worked for a small firm briefly. But pretty soon thereafter, I joined the Committee for Public Counsel Services, motivated by a desire to start being a part of responding to violence, harm, and trauma in people's lives in a way that used my analytical skills. Several of my first trials as a public defender were with clients from whose cases other lawyers withdrew, unable to work with a client who was responding to trauma or mental health or system involvement in a way that made them easy to work with. I grew and developed as an advocate, immediately sensing that learning to communicate with people who are suffering serious challenges was something that I found interesting, challenging, stimulating, and important, not something that I wanted to avoid or get out of. Rather than allowing the work to harden me and make me care less, I found that public defense work opened up my empathy to people struggling through their experiences in relationship to a tough system. Whether they were involved as defendants, as survivors of violence, or as witnesses, pretty much nobody in the court system wants to be there. And nobody feels like they're consistently treated well by the system. I saw over and over again that people can live with and even accept outcomes that are not what they want if they're delivered by a judge who has listened carefully to both sides, who's shown that they're trying to make as fair a decision as possible, and who explains the decision calmly, clearly, and accessibly. As the training director for CPCS, and as a trainer before that, I spent a lot of time on self-reflection, a chance to get to know my own strengths and weaknesses, and just have it hammered into my head that my way or the highway is not something that works in the court system. This experience will help me come to court humbly, ready to listen to both sides, and get as much information as I reasonably can, but then make a decision in a circumstance where the parties are there because a decision maker is needed. It has not escaped me that my ability to sit in this seat today was not made only by me, but by a community of people supporting change and justice in Massachusetts. For the bulk of my life and career, being a judge was not something that I considered. During my clerkship, I was very interested in judges and what they did for work, but I never envisioned myself as a judge because I could not imagine the idea of an openly transgender judge. And I knew, though I didn't talk much about being transgender in court or in the legal workplaces where I worked early in my career, that my gender was a known fact in the communities where I lived outside of work. And that people, at least in my workplace, knew that my gender was a question mark and that I was a leader on the Committee on Trans Inclusion of the LGBT Bar Association. I couldn't see myself as a judge in a court system where I was being brought to the sidebar and told that I was wearing the wrong shoes for my gender, or where another attorney would pull me aside and tell me that I couldn't effectively try a case without a dress or a skirt. Over time, I became more and more direct about my gender, and for so many judges, clerks, court officers, and other people in the system, I was the first transgender person they knew that they had met. I had what might have been or likely was that first conversation with them about why my name was what it was, why I looked how I look, and how I present myself. I've been that first conversation for dozens, if not hundreds of people in the court system. Over time, being an openly transgender trial attorney became totally doable in my everyday, but I still hadn't thought judge. My view would not have changed if it weren't for Adrian Angus, who some of you know. Many of you actually, I think, know Adrian Angus. He was a leader in the Massachusetts Bar Association and the Worcester Bar Association. He was known for his near constant cheery smile, his nerdy love of Massachusetts history, and his ability to fit in to any culture of lawyers, even if he appeared to have nothing in common with them. Adrian was a colleague first and then a friend. When Adrian first told me to apply for the bench, and he didn't ask me, he told me, I reflexively told him what I thought, that my application would not be considered. He didn't let go, reminding me that he thought I was qualified and that I would be good because I like learning new things. Nothing makes me react angrily, even under pressure. But once I thought about it, I realized he was right. Adrian helped me navigate the application process, apply. He helped me prepare for my first interview. And then this fall, Adrian died unexpectedly, still in his 30s, leaving a devastating hole in our team and in the entire bar. The outpouring of response to Adrian's death taught me that one person can touch so many people's lives, and Adrian always did it in a way that was authentically himself and treated other people with such respect and care. It also forced me to navigate leading a team that was dealing with grief, individually and collectively, teaching me on a new level what empathy at work looks like. People are not just lawyers or professionals, but whole people. And that's true of everyone who works in the court system and everyone who's there as a litigant, a witness, or for any other reason. It reminded me why I wanted to be a judge in the BMC, to treat a community and community court with the respect and dignity that everyone deserves, often in some of the worst moments in their lives, which is when people end up in court. The qualities that I just talked about and that Adrian saw in me, my calm under pressure, the fact that I recognize members of the public and people who work in the court system as whole people, my intense empathy for people facing serious challenges, my willingness to listen and show people they are listened to and receive a fair process, and my self-awareness of my own strengths and weaknesses. These are the qualities that I will bring to the bench and that I hope will make me a judge that is as calm, firm, fair, and compassionate as possible. These are the qualities that I hope to bring to the Boston Municipal Court, and I thank you for your time and look forward to answering any questions that you might have.
Thank you very much. At this point, we'll ask Councilor Ziegler, do you have any questions?
I do. Thank you so much, Counselor Anna. Thank you so much. I had the pleasure of meeting with Connor this week to talk about his candidacy for this position. I did want to start by reading into a record letter that I received in favor of his candidacy. This comes from David Nathanson. It reads, "Dear Counselor Ziegler, I am a constituent of yours residing in Salem. I will not give you this. I write in strong support of the nomination of Connor Barouch for Associate Justice of the Boston Municipal Court. I have known him since about 2016. He has an excellent reputation in the legal community for a number of qualities. He cares deeply that the people who come through our justice system are treated as individuals and are treated fairly. He is level-headed. He cares deeply about the quality of the representation that people receive. His work in the Public Defender's Training Unit has really allowed that commitment to manifest itself to an impact that went beyond his work and his own cases. He has made the lawyers around him better. He cares deeply about eliminating racial and gender bias in our courts. I know this firsthand from working on a project with him to develop best practices in jury selection in order to root out discrimination and preparatory challenges or juror strikes. He was able to synthesize practical experience and academic work in an extremely productive way. It was really impressive to observe during our work together. And finally, Attorney Barouch is brave and committed. I can hardly imagine the challenges he faced as a trans lawyer in the rough and tumble world of criminal courts. Whatever those challenges were, he clearly surmounted them extremely successfully. This is exactly the kind of person we want in the Boston Municipal Court: smart, calm, fair, brave, and committed to justice. I wish I could be there to present in person to support his nomination, but I only learned unfortunately, I haven't. Cannot do better than Attorney Barouch, and I strongly urge you to vote to confirm his nomination. If you have any questions, please reach out to me. So I wanted to take the time to read that into the record, because it was important enough for someone to reach out to us and to me, through me directly, to express their support for your candidacy. And so, and as I read that, during our conversation, one of the things that I asked was, how would your colleagues describe you? One of the things you said was calm, and the other was nerdy. And I always like to verify, so I can say within this letter that I received and within the 2 testimonies we heard in person, calm was used in every single instance. So you proved that to be right. You talk a lot about your experience as a public defender, and how you'd use that to impact your ability to serve from the bench. I wanted to dig a little deeper into some of your comments and have a deeper conversation. And so at the BMC, from the bench, you would be interacting with folks with diverse needs and diverse abilities, from language access to housing insecurity, to some criminal involvement as well. How would you intend to reduce harm in your conversations with individuals who may be approaching your bench from a vulnerable state?
Thank you so much for asking that question. I think that figuring out how to reduce harm, especially around areas of language access, diversity, and anytime someone comes into a courthouse, especially if they're not a lawyer, I can imagine feeling alone and intimidated. And so I think that everything the court can do to reduce that harm is really important. Whether that's normalizing the use of interpreters and not acting like it's a big problem to get one. People are entitled to interpreter use. Whether that is finding ways to learn to pronounce people's names right. And I know from my work, I've practiced that lots of times and take notes and make sure that I learn to get it right. All kinds of different, I think, practices like that could just help make the work in a courthouse better.
Whatever happened to Charlie Baker?
Apologies, could we? Sorry.
Okay. I will appreciate joining the Boston Municipal Court, where I know there's several different committees, including Access to Justice and other committees that are really working on collectively figuring out.
It's all about the 0.01%.
Who reviews advice in situations like that and will learn from, will definitely be the person who's keeping up to date on advice on how to best.
Thank you. And apologies for the interruptions. We're trying to mute our participants who are participating virtually. So please ignore.
Just like courthouse.
Well, then you passed the training, right? You need to be able to be on your toes. So it's a good job on that. And so also as part of BMC, there are a number of specialty programs and resources. How would you, such as, substance abuse resources, resources for victims of domestic violence, how would you look to support and or expand access to those resources?
So I think that resources for people in situations where they need help, like domestic violence, like substance use, there's a number of different areas where people come into the courthouse because they need something. They're not there because they want to be there. They're there because they need something. And I think the more that the court can do to help people access the existing resources, but also to help advocate for more resources and really connect people to resources that fit. I think listening to people and trying to help understand what is someone, what might be a good match, and maintaining those relationships in the communities. And I'm looking forward to working in a community court where you really can maintain a relationship and get to know the services that exist.
And so, you know, in this role, there's a need to be flexible. There will be situations that won't necessarily fit within the 9 to 5. There may be some after hours relative to things such as protection orders and or warrants. What is your philosophy on being flexible and being available after hours?
I think being flexible is so important for judges to be able to meet the needs of the community that they're serving. And I'm certainly someone who's able to be flexible.
And my last question is, assuming that, you know, you are confirmed in this role, the intention would be for you to serve for a very long time. What would be your philosophy and your approach to professional development, and what sorts of resources, if any, would you seek to promote that?
So I think the good news, I think all judges should stay informed. And I think that's really important to stay informed both on the law and on changes in the communities where we work. Because over time, I think about the difference between when I began practicing law and now, and the resources available are just totally different. And I think it's really important for judges to stay up to date on those. As someone who's worked in training for the last, I can't tell you the number of years, but you probably can because you have the materials, but for the last number of years, I've worked in training. And so I'm really interested in MCLE, the trainings that they offer. I also tend to be someone who looks to see what's available nationally to give us ideas that maybe we don't have here. And so I am, and of course, reading the case law as it comes out each day.
Thank you. I appreciate you taking the time to answer my questions. And for the record, we did spend an hour speaking and I asked you a whole set of other questions. So thank you for being diligent in your responses.
Thank you very much.
Thank you very much. Councilor Paul DiPaolo.
Thank you, Counselor. Good morning.
Morning.
I want to note first that my colleague, Counselor Kennedy, has a family medical issue and he's playing emergency grandfather. So I know he would otherwise be here. Good morning. I'll start you mentioned Attorney Adrian Angus, and I know, folks like myself were hoping he'd be on the bench one day. But for sure, those who knew him who pay attention know that he's sent ripples upstream that are being felt on the bench right now. So that's kind of an uplifting thing to know. You talked a lot already about dealing with complex trauma that folks in the court experience. And my colleague touched on that a little bit at the beginning of her questioning. So I want to talk a little bit about that. In your application, in several of your cases, you talk about de-escalation skills and communication skills when it comes to a trauma-informed approach. And I know you've spoken kind of broadly about systems, but what are some of those de-escalation techniques, or what is the toolkit that you bring as a judge and you bring currently as an attorney?
I'm so excited that people are thinking about trauma and making sure that judges who are on the bench are responsive to trauma. I do think de-escalation skills are really important, and especially matching what skills being used to the person and situation. I think that's really one of the key elements of the judge. You're not the only person in the courtroom when something happens. There's lawyers, there's other people who might know someone who's in a particular situation better than you. So I think one of the things that I would be doing is looking to competent people in the courtroom. But I do think that there's some skills that apply directly to the bench. I know it's almost a joke now, remaining calm is a thing that I'm known for. And I think being able to have a calm affect when someone is in an escalated situation makes a huge difference, and listening to what the things that are triggering the problem. I've seen judges have all kinds of creative solutions, whether it's thinking about calling a case last so the courtroom is less crowded, calling a case first so someone has less waiting time. I mean, those are opposite things, and I think there's a lot of de-escalation skills that really do vary almost that greatly depending on what the person needs, like whether first or last. Those are opposites, but they both could be really helpful. I think similarly thinking about some of the things in a courtroom that are particularly traumatic for people to see. You know, I've seen cases where people who are victims on a case are still traumatized by being too close to a court officer, and the person's not really even there for any kind of custodial reason for that person. So really thinking about what can we do to be flexible.
Can I jump in? So as an attorney, you are aware of that relative to your client, and as a judge, how will you be sensitive to that?
Thank you. So first of all, I would take very seriously concerns that are raised to me by the lawyers in front of me, by the court officers and the clerks. I think maintaining a relationship with all the courthouse players will help me to be able to be sensitive to issues that come in front of me. And I also would be able to use my own skills to be able to see if someone is in a situation where perhaps they're moving quickly, or I mean, I would be able to see some of the things that come up that would cause me to maybe ask attorneys to come to sidebar and say, okay, well, what can we do to make this situation livable? Particularly in situations where it's a pretrial or it's some kind of preliminary proceeding where there should be a way to make it not traumatic for anybody.
Because it's so busy in our courts. So it's great to hear your approach, without putting words in your mouth, that a trauma-informed approach is kind of a starting point or a lens that you approach every person coming into your courtroom with. I appreciate that. So you have this outstanding perspective and experience on those kinds of issues for folks who might be in the court. You've been a public defender almost all of your career, right? Do you come in with a bias as a defender? You've worked so hard to raise evidentiary issues and to advocate for your clients. And is that a bias you have to overcome as a judge? Does that develop biases?
I'm glad you're asking a question about biases, because I think that what we're looking for is an unbiased judiciary. Everyone comes into a job with experience or backgrounds. I would be looking forward to the opportunity to get to know and learn from other judges who I'm working with who have other experiences. I already know and have been in touch with judges who have experience as prosecutors, for example. So I do come in with the experience that I have. I'm not someone who is not empathetic to what people other than defendants in the courtroom are going through. And certainly hopefully I've interacted with prosecutors and defense attorneys and involved in cases in a variety of different ways, including as a defense attorney, of course, representing people who are being asked to testify who are often victims in a case. So I've certainly had a number of different cases where I've represented folks who are victims of cases.
When it comes to access to justice and accommodations in the courtroom, COVID-19 was a challenge in that regard. And some folks had concerns about how to implement everything and maintain constitutional rights, et cetera. And you mentioned the case, I believe it was, of course I don't have it in front of me, Correa, where there was complex medical issues you mentioned. What were the, don't tell me what the complex medical issues were. What are, like, is that an example you could provide of accommodations that would be unconventional?
So I actually recently tried another case that involved medical accommodations as well. I think that, so some of the accommodations I've looked at have included scheduling, thinking about what periods of time are needed with breaks, how much of the day can be covered if there's a need for a medical appointment, in one case dialysis, for example. So it was Monday, Wednesday, Friday, but thinking about things like that for medical accommodation, but also things that maybe don't relate to scheduling, but are as simple as what kind of seating a person is able to sit in, like whether a chair like this or whether a different chair, those kinds of things come up sometimes. Everybody's different, but I've definitely, you can request accommodations in a few different ways, but I've definitely requested a number of different medical accommodations and trials.
Do you have time left, Counselor?
Yes, I am.
The ever changing landscape of science and our understanding of things. And there's a lot of issues of interest around that, including around expert testimony and qualifying experts. You've had experience with that. I'm curious about brain development and the way that that is being our increasing understanding is being reflected in the courts. Do you have any experience thinking about that or working on issues around that?
I have experience, in terms of the brain development issues, what we have all known from our lives, but science has been teaching us, which is sometimes how this works, is that kids and adults don't have the same brains and don't make decisions in the same ways. Teenagers and adults are not the same. Young adults are not the same as people whose brains are fully developed. So these are things that the court, especially in Mattis recently, but has been developing in terms of understanding of what decision making looks like at different stages of life. And I think likely also for different individual people based on their individual circumstances. I think the court is, the SJC has made decisions around this, but certainly there's litigants continuing to raise it. The science is extremely important to learn.
I guess my hope is that when I read Mattis or the related decisions, and the decisions are narrowly tailored to the situation before the court, yet they note that the evidence scientifically expands beyond the particular issue before the court. So what I hope is, in whatever extenuated hypothetical appears before you, that you're open to following that science, even if it's opening a new trail, right? We know that that development continues into the 20s. And we know that childhood trauma delivers it as well. And I hope for judges who are sensitive to that and are interested in probing for those kinds of mitigating circumstances. Is that you?
I think it's frequent that there's an issue where the SJC has ruled on some specific component of an issue, but there is not a decision on broader issues or on other issues that can be raised by similar science that the SJC has nodded at. It seems like it's a trial court's judge to carefully consider the evidence in the case before them in order to make a decision about how to apply that, but certainly ignoring science that's before a judge, that's not something I would do.
I thank you for your consideration and time. I'll just note that, as I noted to you outside in the lobby, I knew your name before from Adrian. So that's really all I needed to know. I supported you. But thank you.
Thank you very much, Councilor DePaolo. Councilor Jacobs.
Welcome. Congratulations again on your nomination. It's a pleasure to see you again. And I just want to thank you for the rich conversation that we had. Really, I learned so much. I have so many notes to follow up on things that we talked about that I now need to go down the rabbit hole on. I want to echo, and I told you this already, but Adrian's death was a great loss. I met him about 1.5 years ago at an Access to Justice Commission meeting where he told me about you. So I too had been aware of your application and existence, and I'm so happy to see you nominated. So you guys are amazing because I literally half my I'm gonna dive in on the science as a part 2 though. And just reframe it a little bit around emerging adulthood science, which continues to articulate new learnings and understandings, but also science around understanding different areas of neurodivergence and other areas where science is developing forensically. And there's a broad, when we talk about science, it's not one thing. And of course, like right now, I think the fixation too on the impact of AI. So science for me is a very large landscape with implications that impact justice in so many ways. And so I guess my question is, given how much you've talked about today, but also in our conversation, talked about having been the science kid, and fascinated with science. I just want to hear from you, how you'll stay current as things do develop, and then in the event that you haven't maybe heard of a thing, but it comes before you as new science presented to you, I guess your approach to taking on board emerging science, and the implications that it might have.
I'm glad that everyone here is so interested in science today, because I am too. But I also think it's a really important thing for judges in general to be interested in. It's not always the case that people like reading and listening to science. I think one of the things as a judge that I've seen great judges do is really recognizing that intimidated by numbers or statistics or p-values or any of that. I wouldn't be intimidated to read and hear about that, but I would be expecting high quality litigation to include to include some of that either scientific material or testimony. And I would listen really carefully to that. And I don't think I'm the type of person who, if something is complicated, I certainly would give the parties a chance to brief it and take their time so that I'm able to make a decision that's well reasoned, having listened to both sides, depending on what the science is. I mean, there's some sciences that you become familiar with, you know, fingerprints, DNA. I'm not saying I'm an expert in it, but I've certainly seen it in many, many trials. But things still change even in the sciences that we think we know. And I'm not someone who thinks, not working in a lab, working in a courthouse, I might not be up to date. And so I would be looking for the parties to raise new information about science and about other things.
Totally fair. I guess my question is more also about, I guess, adaptive thinking, in that if your understanding was X from science, but then new learning comes that maybe contradicts fully what we thought before, which happens, or just, you know, articulates it in a new and different way that has more implications that we didn't understand before. Your adaptability to new and emerging science trends as they come before us.
Yes, I've been wrong before. I'm open to learning that I've been wrong before. But I find that really interesting to learn something new. So I don't think I'm someone who would be resistant to being presented to new science or new information, especially in areas where there is a lot of research going on right now. You know, neurodivergence is a great example where I've helped participate in and lead trainings about some of the ways that that defense attorneys can do a better job with working with neurodivergent clients. But there's always new ideas, new things to learn, and new training to be had. And so, and same thing, I think, with science as it develops. I think we should be open to learning that we were wrong before. We've certainly been wrong in the, I mean, looking at the history of how we kind of got to where we got in court, further back you go, you realize there's things that have changed, and change is not always bad.
No, I appreciate that. So I have like kind of a series of connected thoughts that I want to talk to you about. So that leads on to one of the conversations we had around access to justice and accommodations when we're talking about different populations, be it, you know, there's obviously the language access, but neurodivergence is an area, or not even just neurodivergence, but disability and cognitive function that may be impacted by a TBI or just developmental delays or what have you, where it's, from my perspective, it's not as developed in the courts. A process around accommodations, and maybe it's a little more individualized by judge and by court. But your thoughts around your experience with having clients who fit that category, and accommodations you've asked for, and accommodations that you think would be beneficial on a broad judicial basis across our courts.
I would be looking for opportunities to create access to justice and grant reasonable accommodations to people based on a variety of disabilities, whether they were physical, whether there was an intellectual disability, whether there's mental health, neurodivergence, any of those things. I think over my career, I've learned, I think I mentioned to you, you know, I had for years been hearing from people on certain medications, it's hard to get up and be in court at a certain time. I hadn't even thought to ask for an accommodation of a later call for that reason. And it was my own mistake to not have asked, because when I asked, it was possible. So I think also some of it is communication, and I know the access to justice committees of the court are working on that. That's something that I would be interested in participating in collectively, but I also, as an individual judge, would be looking for opportunities to do the right thing, not just for defendants, for victims, for people in court, for all different kinds of reasons. There should not be a lack of access due to an unaccommodated disability.
No, I appreciate that. I'm just gonna ask one more and then pass the baton. I just wanted to give you an opportunity to talk, you mentioned in your statement, and we talked about it being a camp counselor and the camp that you have been involved with for so long. And I would like to give you the opportunity to talk about that in a little more specificity about the type of camp it is and the work that you do there, but also when we talked, and I think maybe in your application, I can't remember right now, you connected that experience with your skills, some of your skills and approaches in de-escalation and trauma informed and other elements that we've alluded to today that are important to us. So I just wanted to give you the floor to address.
So the camp that I work at is for kids with serious illness. It's connected to my ex-husband has hemophilia, and even there as a kid, we actually still both volunteer there. And so I do have a decent amount of training in working with people with disabilities because of that work. The camp, as it probably is evident from how I just described it, but there's a lot of adults with disabilities or who've experienced serious illness as well as kids. And so I'm used to working with people at the peer. I'm also working, you know, so I'm also used to working in the capacity as a sort of camp counselor. There's a few different roles of camp counselor there, but amount of detail is not necessary. But that is something I have a fair amount of training in, thinking about different ways that people communicate, different ways that different accommodations that can help someone be able to fully participate in either a conversation or an activity. And I think those are skills that I've definitely brought to my job as a public defender and that I would bring to the bench.
I appreciate that. I could ask you questions all day, but I'm gonna leave it there and pass it off, but thank you so much.
Thank you very much. Next, we'll hear from Councilor Tamisha Civil.
Council. Congratulations on your nomination. I want to say that I first met you when I started my career in Dorchester Court as a VWA, which is a victim witness advocate. And I can honestly say that you do practice what you preach based on your actions and your compassion for those that you represent as a defense attorney, especially those who come from marginalized communities that don't look like you. And as a former probation officer, I know that you have constant contact going up that requires you to go above and beyond to find resources and access for your clients, such as substance abuse, mental health, batters program. And I think it's very important for people to know the work that goes into being a defense attorney and the work that you do for your clients, especially those who really do not have the opportunity like their counterparts. And I want to ask a question about accountability. Given the opportunity that you become an associate judge in BMC, how will you hold attorneys accountable, making sure that their clients show up, making sure that their clients are attending these programs that you set for them as conditions, making sure that the information that you need to make a decision, that they are bringing all the information forward to you. Oftentimes, when you're in court, you have a lot to observe. You can look around, you sit in court for hours, and sometimes you wonder what's going on because cases are being pushed forward, you're getting another date, and the case is just stagnant. How important to you is to hold attorneys accountable to make sure that those that they are representing, they're getting the access and they're getting the treatment and they're doing their job and not just taking a case. So I wanted to ask that question.
Thank you, and I'm glad you asked that question because accountability is so important for all of the people who work in the court system. I think a lot of times we talk about accountability, but we're not talking fully. And I think that you're right that attorneys, including defense attorneys, should be communicating with their clients, making sure they know where they're supposed to be and when. Getting information that is going to help a judge make a decision, especially information that that they should be getting if they're zealously advocating for their clients. I've certainly worked in training at CPCS, and I know that there's a variety of skill levels and backgrounds of the defense bar, which sounds like is what you're talking about. And I think it's really important to make sure that as different, it would not be I would not be the backup defense attorney in the room, but what you're alluding to of people coming to court unprepared and not being ready to do anything on a court date, that's not something that would fly well with me, to put it any better way. I would be looking to see people who are advocating for their clients on both sides, because that is how the system works, is that there needs to be competent counsel on both sides.
And we had an opportunity to meet, and I've learned a lot about you. I've asked a lot of questions. You did tell me a story that you kept in touch with a client. I would love for you to share that, how even after the case was resolved, that client of yours was able to succeed, get married, and find a job and want to live a better life and to start a family and to be able to move from their old ways, I would say. And how important was that for you to see that you planted a seed in that individual's life, and looking beyond what they have done, but being able to correct the mistakes in their lives?
Thank you for asking about that client I had when he was a very young person, because I know we're talking about raising the age at times now, but this is someone who was 17 and considered an adult at the time. And I do think it's really important to understand from people what their own goals are and what it will look like for them to meet them and be open to those goals changing. It's really exciting to have the opportunity to see someone develop and grow. And that's what I'm excited about being in the community courts, is getting to see that happen. I don't know that I would say that I was like responsible for planting a seed or anything like that. He had that motivation himself, but it can be really hard if you're involved in a gang or if you're involved in doing something that even in your future you don't want to be doing forever, but you're sort of feeling stuck there. And I think the system can do a lot to remove some of the barriers for people to be able to get those barriers out of their way and move on to the lives that they want to be living. And hopefully that involves no more court involvement or reduced court involvement or involvement for less serious things. But it's really exciting to be able to run a court system where you have the chance to see people. Thank you.
Okay, thank you. Next, we'll hear from Councilor Maradona.
Thank you so much, Council. Attorney Barouch, I really appreciated meeting with you and our conversation and getting to learn more about your work, which I've had some familiarity with. You said in your opening statement, and you wrote something in your application, something that I think may be the single most important thing that a judge can do. You wrote, "I have concluded that people are able to accept a ruling adverse to them and feel well treated by the system if they are treated fairly in the proceedings." Tell us what you will do as a judge to make sure that when someone leaves court, they know that they have been treated fairly and that we have upheld equal justice under the law.
That's a big one. I hope that's what I hope to be able to do. And I think that making sure to listen to everyone who's in the courtroom, to explain what's going on, and particularly the reason. Sometimes the law is unclear to people and a decision is being made based on law that they're not even sure what you're supposed to be weighing or balancing. I think the more information that people have in an accessible way, and I know that sometimes those of us who are in court all the time speak in what almost feels like a code language to some people because we know section numbers and statutes and all these inaccessible things, but being able to use regular words about what's going on enforce the system and listen, and then explain a decision. I think those are really, I've seen people able to feel like they're treated fairly, even when they don't get what they want.
So because of my own work with the Committee for Public Counsel Services, I have had the privilege of being in some of your trainings. And I know how good you are. And so I'm hoping that you can train some folks on something that's really important. And I want folks to know before I say what it is, it's going to sound really dry and awful, but it isn't. This is a really hot issue. There are a lot of people in this room who know exactly what I'm talking about, which are the changes in Rule 14 of the Massachusetts Rules of Criminal Procedure, which governs discovery and prosecutors turning over evidence to the defense. The new rule goes into effect March 1st, and it no longer uses the term exculpatory evidence. It establishes a duty to disclose items of information, quote, favorable to the defense, and provides 19 specific ample examples of what that would mean. There was a recent story in Mass Lawyers Weekly in which they talked to members of the defense bar who reported that they anticipate that judges will have to use their term, hold prosecutors' feet to the fire. Do you think that's true? And what do you foresee in terms of ensuring timely compliance of Rule 14? And again, if you can train us a little bit on why this is so significant, that would be great.
So potentially exculpatory evidence or evidence favorable to the defense should be turned over. It's required by Rule 14. It's required by the Constitution. There's no real ifs, ands, or buts about that. I think this new rule spells out some specifics in places where maybe some people had found that to be unclear. And it perhaps clarifies favorable to the defense. At first, when I looked at that, I thought it sounded very similar, but I think it clarifies that this is favorable for motions and for, I think, beyond just whatever traditionally exculpatory meant, although I think arguably Brady, I'm not sure what was required before, but it's very clear now what needs to be turned over. In terms of holding people's feet to the fire, my experience practicing in Suffolk County is working with a lot of prosecutors who have an open file policy. Doesn't mean that there's never been mistakes, but I think my expectation as a judge is that either favorable to the defense or exculpatory that's covered by Rule 14 or the Constitution, that should be turned over because people have a right to try a case with all of the evidence that the government has that could help them defend themselves. And that doesn't mean they have a right to win a case, but it means that they shouldn't be trying a case when the government has any kind of information that they should be able to use in their defense.
We had a pretty broad discussion, and I just want to just say again how much I appreciated having that conversation with you, getting to know you better. I know that Counselor Iannella has spoken very highly of you. I got letters from folks. I got a post on social media last night saying, he's great. It's a pleasure. Thank you.
Thank you very much. Counselor Kennedy.
I apologize for being late. I get stuck, not stuck. I had a little emergency where I had to watch my granddaughter this morning. I do have a problem. I've got the wheels on the bus stuck in my head. I was listening to the whole thing as I was driving in here, and I have to say that I'm pretty impressed by the questions that were asked, especially by the newer members. They were pretty well thought out. We had a very long conversation yesterday, about an hour or so, talked about a lot of issues. I'm very impressed. I congratulate you on your nomination. I'm going to ask you one or two questions, not a lot. Everybody's covered a lot. You covered a lot yesterday. But I want to talk a little more about, I think somebody touched on restraining orders already, but I want to talk about those a little bit. Do you think that too many are issued?
So there was, in terms of whether there's too many issued, I actually don't have enough information to make a general decision. You know, I don't know of every restraining order that's issued.
You're going to be doing restraining orders every day. You're going to be sitting in court every day, and you're going to roll your eyes and say, I got another restraining order. And, you know, people absolutely, when they're needed, absolutely should be able to get them. And the appeals court keeps slapping down district court and BMC judges saying you're issuing them when you shouldn't be. And the judges still seem to ignore that. How are you gonna handle it? I know you haven't had a lot of experience with the problem, maybe on the other end, defending a violation, but in terms of restraining us, how are you gonna handle that when you're looking at it and you're not so sure that it should issue?
So I think, I'm sorry, I didn't answer your question initially, but I think this is a really important question because restraining orders impact people's liberty. They impact people's jobs, people's immigration status. It's a very serious situation to have a restraining order issued against you. And so because of that, I think it's really important that a judge looks really carefully at what evidence is being brought in. There's a couple of stages. So in terms of in a one-party hearing, you're hearing only one side of what's going on.
And that stays on the record.
It stays on the record.
That's the problem.
It's
It
possible.
may not issue later, it's on the record, and that person's stuck with that forever. And never had an opportunity to be heard.
Exactly. And so it's a really serious situation where I think the judge needs to be looking at questions of what evidence is available for them to look at, whether there's corroboration, whether there's, obviously there's situations that are very serious, injuries, witnesses, police reports where police witness, that's one situation. There's also situations where there's really serious credibility questions. And a judge needs to be looking at all of those circumstances in order to make a decision. A judge cannot be a rubber stamp granting every restraining order application, regardless of how the evidence is.
I think that they're overused. I think too many of them issue, and they do have a big impact on people's lives. So I hope that when you hold those hearings, that you listen very, very carefully and make a measured decision based on the evidence that's there. A lot of judges, the default is, well, if they don't violate it, there's no harm, no foul, so I'm going to issue it. And there is harm and foul. There are problems that go with it. You know, even when you come in and out of the country, you get hassled. I hear about it all the time. The new restraining order statute that was slipped into the revenge porn statute, the expanded restraining orders, making it actually a lot easier to get one. They talk about, one portion of it talks about, and I read it last night. I was really bored. It talked about you can get a restraining order if somebody abused the legal process and brought complaints and things against people that they shouldn't. That's actually in the statute. I was stunned when I read that. I read it about 3 times. And it gave me pause, and I wondered, could somebody get a restraining order because somebody abused the process by trying to bring one against someone? Because people do. People do it to try to get a leverage in a divorce. People do it to try to get custody of kids all ahead of time, sort of things like that.
This might be more honest than you want me to be, but it sounds to me like I need to read the revenge porn statute tonight. So
There was nothing on TV last night.
okay, fair. No, but I mean, in all honesty, I'm not sure the answer to your legal technical question. That is exactly the kind of thing.
Well, let me put it another way. Should there be ramifications against someone who brings an application for a restraining order that's frivolous, that are fraudulent?
I think that's a great question because fraudulent and frivolous applications do happen. And it's certainly the case. Anyone who's been in the BMC or the district court has seen people come in, apply for a restraining order, come in later and say, my original application was false. That certainly has happened, not once, not twice, but
All the time.
all the time. And I guess I shouldn't say literally all the time, but it happens very frequently.
Lot.
I think that that's a really serious situation for the reasons that you raised, that it really impacts somebody's life, work, housing potentially. And so it can't be the case that there's no ramifications for a person in that situation. I guess that's the answer I can give you. It is absolutely wrong that people are using the restraining order system to evict people or to get revenge or to do things other than maintain the safety that statute is designed to protect.
And I think it also does disservice to the people who actually need the restraining orders. I really do. They're an absolutely necessary tool to protect people that really need them. And I think that's a shame. The couple of things, and I'm going to finish up. As I said, we talked for a long time yesterday. Very nice conversation. First of all, we have at least one mutual friend that'll kill me if I don't vote for you. You know who that is, okay? So I am gonna be voting for you next week. I'm very impressed. I've seen you around the courts. I've seen what you do. You're a great lawyer. Counselor Ionella is a big fan, your neighbor. He's been very, very supportive of your nomination, and when he puts your name in nomination next week, I'll be voting for you.
All I can say is that our mutual friend's not very murderous, though.
Thank you very much. I don't have many questions, just a follow-up on Counselor Kennedy. Someone brings a fraudulent application for restraining order. Yeah, there should be ramifications, but like what? What can you really do? I don't know of any judges who do any, you tell me, what, and you may not know the answer. What options do you think you have, and what would you do?
Well, I think the question that a question that raises is whether there's any civil remedy. The answer to that is I don't know. I would be open to learning, and I think the way that you learn whether there's a remedy is when someone raises that issue. But in terms of the ramifications, I know there's a number of different courthouses that have informal procedures to deal with people who repeatedly do this to a variety of different people. But if it's someone's first time doing that, I don't know about the ramifications for that person. I think what should be done, though, if it's known to be fraudulent, for example, video comes up later, contradicted, something that I think it should be made very clear on the record in a way that the person who was harmed by the false restraining order should be able to have some at least way of showing what happened. The process is very serious, and it's important for restraining orders to exist for people who really need them. And the abuse of the process, as Counselor Kennedy indicated, really harms the people who really need that process.
Thank you. What's your personal feelings on matters that would come before you, assume you're confirmed by Zoom? Or are you one of those judges that want people to come in person? And I can say this, there is no consistency in the district court. Okay, there's no consistency in the district court at all. Some courts, they're all laughing at me. Some courts insist, even if you're requesting a continuance, you must appear. And I'm not talking a trial. I'm just talking, pre-trial conference and, case management. What's your personal opinion, and what will you do if you're confirmed?
One thing that you and I can definitely agree on is that there's no consistency, as every court's doing it differently. I think that, and I'm glad you raised this, because I think Zoom can be an effective tool for some situations, and it can really harm other situations. And I think that, I know that's not a direct answer to your question, but as an example, I did one evidentiary hearing over Zoom, a Daubert hearing, and it was very difficult to do an evidentiary hearing over Zoom. It wasn't good for the reasons because both sides had out-of-state expert witnesses, and it was deep in COVID. So it made sense in that moment. But I think my bias for an evidentiary hearing or a trial would be in person. You're talking about in a pretrial context, and I think the
Pretrial, status conference, continuances, that's what I'm talking about.
I'm not here to make the life less convenient for defense attorneys, for prosecutors if needed. For example, sometimes it's helpful if a prosecutor on a bind over case is appearing from another location and make it inconvenient for people in the court system. I know I've had clients who've managed to not lose their jobs because they're able to appear over Zoom on a break instead of spending an entire day waiting for the case to be called. So I think it depends on the circumstances, but I'm not someone who's close to the benefits of Zoom. I also recognize that there's some downsides, and I worry about things like people waiving their rights, important rights over Zoom, and making immigration mistakes or making mistakes that can impact them for a long time. But in terms of pretrial conferences and that kind of thing, I don't have, I'm not there to make life inconvenient for people.
So is it fair to say that status conference, pretrial conferences, you have no problem if people want to be on Zoom? I just want to see,
I would say, I think it does depend on the circumstances,
Oh, and
a 5-year-old case.
well, let's make it real easy. There's a case on next week. It's the first time it's on, because this is what happens out there. Every court, depends on what court it is. It's a civil case. well, that could be any case, one of the parties asks for a continuance, simple as that. Let's say it's the first time on. There are some judges in the Commonwealth who say, if you want a continuance, you must appear in court. So why do so many attorneys object to that? Because the real loser is the client. No lawyer is gonna go take, I don't go to court anymore. Counselor Kennedy's in multiple courts every week. So if he's in the greater Boston area, if he's gonna go to Worcester for a continuance, the loser is the client. Because he's gonna have to charge the client more money. I'm talking simple things like that, your position.
So in this situation where it's as simple as a continuance, a first continuance for, an early continuance in the case where the technology in the courthouse is working, which I think is it's not a situation where there's bad Wi-Fi or where no one can hear anything. I don't see a reason not to do that over Zoom.
What if the chief has a policy out there? Okay, now these things happen, we hear them all the time, and says, listen, anyone wants a continuance, they gotta appear. Now remember, nobody can fire you. Okay? So you get the orders from above. Initially, you're gonna be in this court, that court, you're gonna be in different courts. Consistency is an important thing. Oh yeah, so-and-so won in front of Judge Barouch, he was really fair, he gave me a continuance. Next week, he made me come in person. So what are you gonna do? The chief says, in my court, that's the way it is.
So I think what the chief says is a factor. There's also emergencies and changes that come up that don't always fit the mold of the exact, before the resume. Sometimes you'd be requesting a continuance on papers, right? So it's not the case that everyone has always appeared in person for every single thing. However, I think the court needs to recognize that things in people's lives and people's law practices do come up that require changes. I also recognize that there's some chiefs who literally have removed the computer from the courtroom in terms of the Zoom computer. So it makes it physically hard to make a Zoom happen, but I don't intend to intentionally make attorneys come in for unnecessary dates in order to cost the client money or.
But if it's the first continuance, a lot of attorneys who were sole practitioner, Attorney Kennedy, Attorney Juvenville, who was on the council, no longer, they're in multiple courts a week. And you know what? They have to pay the rent. With all due respect, you didn't have to worry about the rent. Yes. They have to pay the paralegal, the heating bill, the electric bill, the office supplies. So if they get multiple cases, I don't want to go to, Roxbury today, I'd rather go to Dorchester today. You can't move around. So whether it's the first continuance, second, who cares? I mean, seriously, does it make a difference if I'm not talking 5 years old, 10 years old, but does it really make a difference if it's the first continuance or the third continuance? It's all within, say, a year and a half. Who cares?
I mean, I agree with you in that. I don't have a problem with Zoom
I'm even saying forget Zoom. I'm even saying the paper.
I don't inherently have a problem with that as long as the other factors that I have to consider have been met. You're talking about first or second, we're talking about early in the case on a date where, sometimes people need a change in the schedule, and I understand that.
Yeah, you folks, and there's some judges here, you think I'm crazy, but we had a nominee sit in that chair. Okay, and I said, what happens if your spouse says, guess what? 25th wedding anniversary, we're going on Friday to Bermuda. Would you and the case was on a third time, would you allow the continuance? And you know what the person said? I couldn't believe it. Probably not. The spouse should have known the other spouse's schedule. I go, you serious? Well, afterwards, there was a break in the proceedings, and miraculously, the nominee had a different opinion and came back and said, yeah, I probably would grant the continuance. But these things happen. What do you do?
I don't want to stop you from going to Bermuda, first of all. I do want to go, and that won't be enough.
For myself, I don't go to court on each side, so that doesn't matter. Yeah, I don't have any further questions. We had a nice conversation. You're my neighbor from Jamaica. We got a lot of great judges from Jamaica Plain. We sure do.
Week for Jamaica Plain.
Yeah, yeah, it is. Now, I agree. Judge, what's the other judge's name on our street, on May Street, on the right side? Yeah, Jean Marie Cal, another great judge. She's walking the dogs all the time. Yeah. But no, we have great judges from Jamaica Plain. You're gonna be a great addition to the Boston Municipal Court. When your name comes before us next week, I'll be more than happy to support you. But before we leave, is there anyone in opposition to the nomination? Thank you. No one being in opposition, that will conclude the hearing. And thank everyone for coming today. Thank you.
Congratulations.
We seek blessings of the task before us. Bless our efforts with insight, our deliberations with wisdom, our work with clarity and accuracy, and our precision and impartiality.
Amen.
I pledge allegiance to the flag
United States of America.
The republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great. Well, I want to acknowledge our first meeting of 2025 and welcome our three newest members of the Governor Council now acting in their official role. It's good to see everyone around the table. And I'd like to recognize Councillor Jacobs for a motion to record advice and consent for the financial warrant.
So moved, Governor.
Is there a second? Seconded by Councillor Kennedy. All in favor, say aye.
Aye.
Any opposed? The ayes have it. I'd like to recognize Councillor Kennedy for a motion to record advice and consent for the pending list of notaries public.
So move, Governor.
Motion's been made. Is there a second?
Second.
Seconded by Councillor DiPaolo. All those in favor say aye.
Aye.
Any opposed? The ayes have it. And today we have 4 nominations. Let's just go through. Connor Barouch to the position of Associate Justice of the BMC. I understand Councillor Ianella held a hearing this morning, right? Okay, 1 down. Dana Pierce is having a hearing for her to the position of Associate Justice of BMC. That's going to be also Councillor Ianella, and that is today after lunch. Perfect. You guys are getting a lot done on day 1 in 2025. Tiffany Ellis Niles to the position of Associate Justice in Juvenile Court. Councillor Civil, do you have a date and time for this hearing yet?
I will have. a date.
Okay, perfect. So we're going to coordinate that a little bit later. And then we've got another one for you, Councillor Civil. Karen Walensky, also Associate Justice of the Juvenile Court. We'll work to get that one coordinated as well. Perfect. And Councillor Jacobs, I understand you have a point of order related to the rules that you wanted to bring up today.
Thank you. So as a point of order, and a little bit of housekeeping as we start the new term, very excited to have 3 new members. So I'll give a very brief history because I know we've got swearing in to come. So last term, we formed a rules committee, and the rules committee crafted based on the most prior rules that we had found earlier, a list of Governor's Council rules that we adopted and that you have a copy of, you should have a copy of in your packet. And so as those rules lay out the process, I'm initiating for us a new round of rules consideration for our adoption. The first thing I wanted to do was open it up to any new members or existing members who want to be a part of the rules committee. We're very happy to have your membership, your participation, your involvement in crafting the new rules for the term. So you can either share now or yes.
Right with the rules committee, thank you.
Wonderful. Would you also? Anyone?
Be involved.
Fantastic. Okay, so you guys want to also be a part, or you're good to hear what we?
We'll look at what you do.
Okay. All right, so hello to my rules committee. We have a laid out process, so we can work remotely together to craft a proposal for the council consideration. The current rules state that we give 2 weeks for council to receive and consider before we come together for a vote, and we do that vote in executive session, which we will schedule 2 weeks after whatever time we share our work output. I don't know if I need to move for a vote. I feel like.
I think it sounds like you all are gonna not have an informal subcommittee that review rules and will come back as you mentioned. So I don't think anything else is in order today.
Okay, well, wonderful.
Other councilors have any other thoughts?
Thank you for the opportunity to address that, and I appreciate this support.
All right.
Councilor DiPaolo is still on as well, so.
Okay.
The 5 of us, right?
Okay, perfect. Sounds like we got a plan to move, you all have a plan to move forward there. I also want to know, I think you all are aware, but at 12:15 in the governor's ceremonial office, will be administering the oath of office to 2 reps who were not able to participate in the swearing in last week, Representative Carol Ann Doherty and Ann Margaret Ferrante. So appreciate your time participating in that as well as per our requirements. And I think our business is concluded with that. So I'd entertain a motion to adjourn.
So moved.
Motion made by Councillor DiPaolo, seconded by Councillor Ziegler. All those in favor? Any opposed? The ayes have it. All right. First meeting in the books.
How's everybody doing? Good? Hold out there. My name is Christopher Iannella. I will chair the hearing today. At this point, I'd like to introduce the other counselors. Counselor Eunice Ziegler, Counselor Terry Kennedy, Counselor Paul DiPaolo, Counselor Tara Jacobs, to my right, Counselor Tamisha Civil, and Counselor Mara Dolan. Good to see you. Dana, how are you?
I'm great. How are you?
All right, at this point, I'm going to read a letter dated December 5th, 2024, directed to the Governor's Council. Dear councilors, I'm pleased to nominate Dana S. Pierce to the position of Associate Justice of the Boston Municipal Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Maura Healy, Governor. At this point, before we hear from you, I know you have a lot of supporters, friends, distinguished folks, you're going to speak on your behalf. So let's hear from your witnesses first. Okay, we'll hear from them first. The Honorable David Weingarten. You can stand, you got choices. You can stand there, or you can sit there.
Sit if you don't mind. Thank you.
Good to see you again,
Good to
Judge.
see you. Thank you. Members of the Governor's Council, good afternoon. Thank you again for the opportunity for me to be here to speak in support of the nomination of Dana Pierce, a colleague and a friend. I'm David Weingarten. I'm a recall justice. I was formerly the first justice of the Roxbury Division for the last 15 years, and I've been a judge for some time before that. I have had a very fulsome and large chance to get to know Dana in my capacity as a judge. First, in her role as a Superior Court DA, coming to Roxbury to arraign cases that the DA intended to indict. Then, in her capacity as the supervising district attorney in the Roxbury Office of DAs. Then, in her capacity as the chief supervising attorney for the entire county, that would be the district court and the municipal court. Then, in her capacity when she left to go to State Street, and we were merely friends. And then again, with her capacity as counsel at Harvard. So I can tell you that I really have 3 points that I wish to make about. First, she is a terrific trial lawyer and a terrific attorney in general. She's very knowledgeable about the law. She knows how to take a case in our busy community courts from the beginning of the case to the middle to the end of the case. She's appeared in front of me literally hundreds of times to do not only arraignments and hearings and motions, but also trials. I've had the chance to see the deftness and the feel that she has to, if I could say it, color outside the lines a little bit to figure out how to move a case in the most just and fair to the most just and fair resolution. She was always prepared. She's completely comfortable in a courtroom. She has deep knowledge of the law, of the rules of evidence. In this particular regard, her transition to the bench, I predict, if she's lucky enough to be confirmed, would be easy and facile. In that it'd be changing her role, but doing something that she already knows a substantial amount about how to do. The second thing I want to say about Dana is that I had the chance, because of our particular roles, mainly in her role as a supervisor at Roxbury and mine as the first justice, to work with her on a number of courthouse and administrative initiatives and to do things in the courtroom that are not typically thought of as the normal kind of thing. So the first thing is that 10 years ago, almost 11 years ago, I came to her and asked her, would you support the introduction of a mental health session into Roxbury? That is a session with a dedicated social worker, DA, probation officer, in which we were asking the Commonwealth to not go over the Article 30 line to invade their powers, but to walk right up to it and agree that certain dispositions would be allowed by the court that the Commonwealth would agree to them in exchange for getting mental health treatment and getting people back on their feet. Not only did then supervising DA Pierce agree to that, but she provided a dedicated DA, actually more than one, full-time for that session, giving them full powers without micromanaging them to run the session as they saw fit. And that session is now almost 11 years old. And I think with a pat on the back to everyone that's been involved with it, something considered to be something of a model for how district and municipal courts and community courts. In addition to that, it was Dana and me and some other people that sat around the table at Roxbury trying to figure out, is there a way that we could get a restorative justice project off the ground there? Because this is a community in which people often come to us and say, we want more from how the court serves us. And we tried and failed, but in our failure and in our talking and in the relationships that we built, that was part of the seed that I believe led the SJC to designate Roxbury as one of the 4 courts that will be the pilot program for the new restorative justice project. Supervising DA Pierce championed services over sentencing, in which the DA's office would offer diversionary dispositions of cases. She supported 276A or other diversionary programs. That is to say, was willing to give up, to cede the DA's power in order to come to a resolution that was fair and just. So that leads me really to my third point and my last point, which is, and perhaps I should have led with this, because in my mind, this is really the most important point, which is that when people come into a community court, it's usually not for the best day of their life when it's in a criminal case. And what they're looking for is a person who will be fair, who will have the kind of temperament that exudes respect, that reaches out to people, who is accessible as a person and as a jurist, who has good relationships with court staff, who is respected by people and liked by people. Dana Pierce is that person. She is unflappable in the courtroom. When I mentioned to 3 clerk magistrates in Roxbury this morning where I was coming today and what I was doing, each of them independently in different places went, oh, everyone is so pleased with the people that she cut her teeth with in Roxbury to see the progress that hopefully she will be able to make in taking the next step. So with all that in mind, and with my only regret being that because my retirement is coming so soon that I will not be able to share the bench with her as a colleague for any significant amount of time, which is really a deep regret of mine, I humbly offer my highest and most enthusiastic recommendation.
Thank you, Mayor. Councilor Kennedy.
One recall.
Just till March. Yes.
Why can't we do something about that?
It's above my pay grade.
What are you talking about? They can do another recall. No, if we don't fill these slots, they'll need you.
I'm happy to give, if that's the test, I'm happy to give this slot to the next generation of judges.
Let me just say, you've done a great job. I've appeared in front of you many times, as you know, and it's always been a pleasure.
Thank you.
Always one of the most fair-minded judges I've ever been in front of, that's for sure. Appreciate what you've done.
Thank you. Thank you very much. Good to see you. Next, we'll hear from Ms. Dacia Burton Rogers. Dacia, sorry. Morning, good afternoon.
Good afternoon. My name is Dacia Barton Rogers, and I've had the privilege of knowing Dana for well over half my life, and I'm 30 now, to put that into perspective. I'm here today to speak about her profound impact on my life and why I believe she is an exceptional candidate for this judicial role. Dana's influence extends far beyond the courtroom, and her compassion, wisdom, and dedication has shaped the person I am today, moving into a life-changing experience. When I first met Dana, I was just a young, scared girl. I was facing something no child should ever have to endure, a trial against my uncle who had abused me.
At the time, I didn't know how things would turn out. I was terrified of the unknown, overwhelmed by the idea of sharing my story in such a formal, intimidating setting, and unsure of how to navigate the process. What I didn't expect was that one brave decision to speak out would lead to a series of life-changing events. With the help of Dana and the legal team, the process became so much more bearable. Dana didn't just see me as a case or a client, she see me as an individual. She patiently explained what to expect, taught me how to stay composed under pressure, and gave me the confidence I needed to face my abuser. Her compassion and care made a terrifying situation feel manageable and gave me the strength to see it through. Dana's lifelong impact. Dana's support didn't end when the trial was over. After the case concluded, I went on to graduate high school and I invited Dana to my graduation. That moment was incredibly significant to me, a chance to celebrate a milestone with someone who helped me overcome one of the darkest times in my life. Her impact didn't stop there. As I grew older and began my career, Dana continued to be a mentor and guide. She became a listening ear and a source of strength, especially as I navigated the challenges that Black women face, often in their personal and professional lives. Dana's encouragement and advice have been invaluable, helping me face obstacles with confidence and resilience. What makes Dana extraordinary is her ability to inspire and empower those around her. Her compassion, patience, and dedication to justice are unmatched. She goes beyond her professional role, investing in the people she works with, and genuinely caring about their growth and success. I am deeply grateful for Dana's influence in my life. Her wisdom, kindness, and commitment to doing what's right makes her an exceptional person and a role model for others. I have no doubt that these same qualities will make her an outstanding judge. It is my honor to share her impact on me and to wholeheartedly endorse her for this position. Thank you.
Thank you very much. Thank you. That will conclude the folks in support of your nomination. Is there anyone here in opposition? Having heard of no one in opposition, that will conclude that portion of the hearing. And now we'll open the floor to you. And before you make your presentation, if you would like to introduce any family, friends, or supporters, you can do that now.
The most important people are my parents, Al and Vicky Pierce. I have my sister, who's made me cry. Her name is Leah Martell. My brother-in-law, Jay, is here, and 3 of my nephews are here, Colton, Aiden, and Jackson. My niece Lily couldn't miss school today, but they are favorite people. My auntie Ruby is here with my uncle David, my aunt Joan, my cousins Eric, Justin, and Nancy. Let's see, some of my really good friends. Who else is here from the family? My 2 best and oldest friends, Rebecca Murray and Melissa Olson. Lauren Petrigno, an invaluable guide, Judge Erica Reese, who I could not have gotten through this process without, and Sarah McAvoy, who has introduced me to a boxing class that has been a savior during the process. And I think that's everyone. If I missed anyone, I know there's some people on Zoom. Thank you.
Thank you. Now we'll hear from you.
Good afternoon, and thank you, counselors, for having me here today. I am grateful for all of the time you have afforded me during this process and for your consideration of my nomination as an Associate Justice of the Boston Municipal Court. Thank you to Governor Healy and Lieutenant Governor Driscoll for your nomination, trust, and confidence. Thank you to the members of the JNC for your diligent review of my qualifications and for advancing my application. Thank you to attorneys Paige, Scott Reed, and Derek Kesselheim, as well as to Ms. Valerie McCarthy and her team for your endless support and guidance during this process. I've already thanked the people who are here on my behalf today. Please know that I've learned something from each and every one of you that has helped me get where I am today. Last but not least, I would like to thank my family, and not just for their support,
during this process, but the ways in which they have helped shape the person I've come to be. I wouldn't be here today if it weren't for them. And so I'd like to take a moment to share a bit about the lessons they've taught me and the philosophies they've given, where they would, if I am fortunate enough to be confirmed, come to bear on my service as an associate justice. My mom moved from Canada to Massachusetts in her early teen years. Shortly thereafter, she lost her father. It was just her and her mother trying to make a new world for themselves. She's one of the greatest cooks. Everyone here knows her pumpkin bread. And she's one of the gentlest souls. My father is an African-American male of humble origins with 9 brothers and sisters, a fantastic sense of humor, and an unbeatable work ethic. They met in the late 60s while still in high school and have been together ever since. Their path was not always easy, especially not in the beginning. There were still many challenges for a biracial couple, and they faced disapproval and discrimination. But they persevered and worked together to educate those who challenged them and bridge the gaps that divide. After 10 or so years of dating, they bought a house and got married. The house is in Burlington, Massachusetts. They made that house a home where they raised my younger sister and I, and where they live to this day. That home is filled with love and warmth and memories. I can close my eyes and replay the scenes from every Christmas morning where my little but somehow taller sister would wake me every day at dawn to tell me what Santa had left under the tree, of us riding our big wheels down the really steep driveway and hoping we didn't crash either into each other, a car, or the garage, and it's some sort of a miracle that we didn't. Of epic cookouts where every aunt, uncle, and cousin was invited, and we prayed for sunny weather because there was no way we could all fit inside. This big, beautiful, often chaotic, but always amazing family provided me with endless role models. They are teachers and firefighters, police officers and paramedics, caregivers, homemakers, and nurses. We have 10 veterans and counting. They instilled with me the values of service, sacrifice, hard work, kindness, empathy, and compassion. And to be sure, there were hard times as well. I watched loved ones struggle with substance use disorder and learned the importance of second chances and forgiveness. I saw family members fought to find their places in professions traditionally closed off or limited to them. And I learned about the importance of representation, diversity of thought, and of paving the way for those ahead. I learned more about the racism and discrimination that my parents faced as a couple. I faced it myself as a biracial woman who was only one of 5 African-American students in my class. All of these role models and all of these experiences left a teenage me wanting to do and be something big. Type A overachiever, I decided college was the first step, and I knew a scholarship was key. So I did everything I could think of to make that happen. And keeping in mind, this was a teenager thinking of these plans, so I'm not sure how logical they were, but I took AP classes and I played hockey, although quite terribly. I took dance and music lessons, learning somewhere around 4 or 5 different musical instruments. I joined academic clubs and worked part-time jobs. I did get that scholarship, and so at the age of 17, I moved to Boston and enrolled at Northeastern. I immediately fell in love with the city, with the pace and the people and the freedom to explore. I made lifelong friends, the kind of friends that are more like family, who take time off from work to come to your hearings. From there, I went to law school and into practice. I won't recite all the details of my practice, for I know that you've all done your diligence in reviewing my voluminous materials. But 2 things that may not be captured, and 2 things that I would love to share a bit more about the type of lawyer I am and why I'm particularly excited to serve as an Associate Justice of the Boston Municipal Court. I believe that each case is a unique amalgamation of the people involved and not just the file. I ask questions and I truly listen. I do my best to think outside the box so that I can suggest a course of action or a possible resolution that truly helps everyone involved. I love building relationships and community, regardless of one's role in the process. I am devoted to mentorship, specialty courts, and the importance of well-being for everyone working in the courts. For the days are stressful and the work is difficult. I've had the good fortune of practicing in each division of the BMC, a good number of district courts and superior court as well. No matter where I've practiced, nothing has compared to the BMC.
There's just something special about it and something that feels like a second home. I love the hustle and bustle of the larger courts as much as I love the quiet intimacy of the smaller. I love the specialty court program and the way each division adapts to the needs of the communities it serves. I love the communities built within each division of the BMC. And I love working for the city where I live and where I have lived for more than half my life. It has not escaped me that the communities that are served by the BMC face some of the same hardships that my own family members have, whether financial struggles with substance use disorder or mental health, or veterans who have returned from service but didn't have the supports they needed for a seamless return to civilian life. I have seen the tremendous good that a BMC judge can do, whether that is through showing compassion and kindness, listening with an open mind, or help connecting people with the tools they need for long-term success. If I am fortunate enough to be confirmed, I will bring all of these lessons and all of these experiences from not just my family, but my practice to be just this kind of judge. I truly hope that our prior conversations and today's testimony can provide you with the confidence required to confirm my nomination. I thank you once again for all your time and consideration. I look forward to your questions.
Thank you very much. First, we'll hear from Eunice Ziegler.
Counselor, and thank you, Ms. Pierce, for being here today and putting your hat in the ring for this role. We did have an opportunity to speak earlier this week, and during that conversation, it gave me a little more insight into who you were as a professional and as a candidate for the bench. One of the things that stuck out to me in our conversation is that you mentioned that you've worked in all 8 divisions of the BMC. And so I wanted to dig into that a little bit more and ask you, what of that experience best prepares you for this role?
Thank you. I appreciate you catching on to. I have gotten a chance to know the different ways that each courthouse operates, the different preferences, the different communities. I very much look forward to digging into that a little bit deeper. And one thing, so not only that knowledge base, but another thing that I think really about that aspect of my practice that has helped prepare me for this position is the flexibility and the ability to change tasks quickly. I know where all the courthouses are. I know the different preferences of the different courthouses, the different needs of the different communities. I am completely used to the concept of being in Dorchester one day, Roxbury in the afternoon, then covering Charlestown for a day. And while eventually most associate justices do settle into one courthouse, there is a need to be fluid if someone is on vacation, if someone has an emergency. And I have that sort of ability to hit the ground running and to be an immediate help to the team that is the associate justices of the BMC.
And so, in this role, we talked previously about the community, the individuals that will be coming before you to the bench, should you be confirmed. Individuals that will be coming in and out of the courtroom are coming from diverse backgrounds, diverse needs, whether it's housing insecurity, whether it's domestic violence or criminally involved issues. And as a judge, it would be your role to ensure that you're creating access and reducing harm from the bench. How would you intend to do that?
I think you raise an excellent point, Counselor. I have seen from experience and I have heard from victims and community members, not just how scary court can be, but the unfortunate reality of sometimes walking away like they didn't feel heard, or that they didn't understand what was happening, and taking some time to debrief with them to correct that. I have tried to approach my practice with a lens of being trauma informed, so that hopefully I can recognize when people are in need of an adjustment or a moment to pause, to be mindful of that. I myself have taken several trainings helping me recognize those, to think creatively. I have always asked the people I served, what could I have done better or differently? How can I make you feel comfortable? And as a judge, I would bring that experience with me. I would, keep my eyes and my ears open to see if anyone appearing before me was struggling with any of those issues. I would call their attorneys to sidebar and ask, does your client need a moment? Is there anything we can do to make this process more comfortable? What is your advice as the person who knows the client? What can I do to help? What can I do to make this less scary to support you? I would also get to know the resources available in the local community and within the courthouse so that I might create either conditions or dispositions that are well-informed and connect people with the things they need to support them.
In that same line, there are various specialty programs that you're familiar with, substance abuse, resources, language access resources. How would you interact with these resource programs? Would you be seeking to expand them? How would you look to promote them?
I would take the time to educate myself as to what is available. And then also what is missing? What do we need? I really think that there's no such thing as having too many supports and services for the people that I serve by the Boston municipal courts. And I recognize that this is, some of these issues are not just statewide, but nationwide, and there's a shortage of service providers. So thinking outside the box to connect people, to learn more about what's available in the community, and to always be mindful of their needs.
So in this role, you would have a profound impact on the lives of the individuals that come before you in court, should you be confirmed. You spoke about a restorative justice, and one of your colleagues also spoke about your experience with restorative justice programs. What does restorative justice mean to you, and how do you plan to engage with this philosophy from the bench?
I've had the benefit of actually doing a circle training with Roca. And so I have some knowledge. There could always be more. To me, restorative justice is approaching things with a trauma-informed lens, giving people the space, creating a safe space for people to share how something has impacted them, to bring, whether it's victim and offender or community, whoever is harmed, giving them a safe space to express that, but also help, if a criminal defendant is involved, finding out what got them there, what do they need help with, how do we help them understand the impact, and how do we help them, address the root cause that what was the driver here, and so that they not only understand the impact on the community, but they have the tools they need to put themselves in a better position moving forward. I think there's great room for restorative justice in the courts of the Commonwealth, and I look forward to, and I hope that I can be a part of expanding that.
So from the bench, there may be a need to be flexible, given that there are some aspects that you may need to weigh in on after hours, whether it be a protection order or a search warrant request. What is your philosophy on being flexible and being available and after hours, say, after 5 p.m. or on the weekends, relative to these requests?
I think it's absolutely necessary. It's, I think many of the people who know me, work-life balance has been a struggle for me my entire career. I even had a job once where I was on call 24/7 for the Mattapan police station. So it's something that I think is important. These are real people's real lives. There's public safety issues. It's something that is a part of the job.
In the same line of being flexible, and we spoke about this in length in our prior conversation. In today's day and age, it's maybe difficult for people to get to court because of work commitments or just because of transportation or what have you. What is your philosophy on virtual versus in-person hearings? And what situations would one be preferred over the other?
I think Zoom is both a blessing and a curse. I think, leading the district or municipal courts as a prosecutor during COVID, we learned a lot about how helpful, truly helpful Zoom can be. I have a lot of respect for criminal defense attorneys, whether with CPCS or as sole practitioners or bar advocates. Many of them have to be in multiple courts in the same day, and or they need to meet with clients who are incarcerated, which is a huge, huge time commitment. So I don't think that everything can be conducted by Zoom, but I do think there is a space for Zoom. And I think it's a great tool that can maximize the efficiency of everyone's time. I also really feel for those who have to attend court, not because of their work, but because they have to. And the impact having court date after court date after court date can have on their life. It impacts their ability to work. Sometimes they lose their jobs. If they have private counsel, it's extremely costly. And sometimes they're there for hours just to get a date. And I don't think that's necessary. So I would respect the protocols of the trial court. I know some of the courthouses have better technology than others, but I do believe that Zoom has a place moving forward in our future.
And my last question is, the goal would be that you're confirmed in this role, and should you be confirmed, to serve for a very long time. Right? And so potentially in that time, what would be your approach to professional development, and what resources would you seek to further your knowledge base relative to matters pertaining to the bench?
I think everyone working in the court system has an obligation for continuous education and improvement. I think that's particularly important for judges. I know that the trial court has a wonderful education program. I know that the judges of the Boston Municipal Court have a mentorship program. I would fully avail myself of those. I would keep up to date on case law and statutory changes. I also know that the judges of the BMC have a wonderful community where they sit down to lunch and they discuss changes in the law, things that have happened in the courtroom. So I take full advantage of those opportunities as well as time to read on my own to make sure that I'm up to date.
Thank you so much for taking the time to answer some of my questions, and also to meeting with me prior to allow me to ask you even a different set of questions than the ones I asked you today.
I'm happy to do it. Thank you, Counselor.
Thank you.
Thank you very much. Counselor Terrence Kennedy.
I'm kind of afraid to ask any questions because the questions the new members are asking, so well thought out that we don't look dumb.
No, your questions are great too, Counselor Kennedy.
First of all, your mother and father look very proud behind. You can't see them, but I can, and I can see it.
Sat them there.
And they should be. Congratulations on your nomination.
Yep.
A couple of questions, not really surprising questions. Let's start with 58As.
Yes.
Overused?
I think you raise a really important issue. The 58As are a necessary tool that I feel should be reserved for when there is truly a danger to the community. I mean, what the law says, truly a danger to the community such that no conditions of bail can ensure the safety of either.
Well, that's the statute. You say
That's the statute.
you're giving us the statute, but let's talk about what happens practically. Overused.
I
Prosecutors.
Yes, I think they can be. I think prosecutors have a lot of power and discretion. And the importance of slowing down and taking the time to analyze a situation with a clear head can sometimes be lost. And I think 58As are a really good example of when that has happened.
You're gonna put their feet to the fire to get them done right away? Because what happens is, so people know, somebody files a motion for 58A. Most judges say, okay, we'll see you in 3 days, and the person gets locked up. People never.
Excuse me 1 second. Can you explain what, for the people don't know what 58, a lot of people don't know what that is.
It's a motion by the Commonwealth to say that, this person is too dangerous to be on the street, and we want to have a hearing to see if they're too dangerous to stay in the street based on certain charges. And, if the judge finds that they're too dangerous, then they're locked up for pretty much the pendency of the case usually, but, in district court anyway. But what happens is they file that motion. And a lot of judges think, well, they get there 3 days and it's an automatic hold. Do you think that's the situation? You're pulling people out of it from their homes, from
Out
their
of their
families,
community.
people who've never been to jail before.
I think, I know that I would follow the law as it is written in the statute. I think I would.
But everybody says, I'm gonna follow the law. But that's, everybody who sits there says, I'm gonna follow the law. And everybody, absolutely. But I'm in court every day,
I know you are.
okay? I've been in court every day of my professional career, practically every day for 41 years, okay? And I see these prosecutors filing these motions all the time on a lot of cases that aren't gonna go anywhere. But people end up in jail on a case they're never gonna get convicted of. So when they file that motion the first time, I had an incident I brought up before, up in Salem Court. It was a legal secretary to somebody in my town, okay? Never been in jail before, got in a fight with her daughter over her daughter cleaning a room, and it turned into a shoving match. No record, in her 50s, the DA up in Salem filed a motion for a 58A. And she was held actually for 5 days because a weekend fit in there before I got involved. Are you gonna hold prosecutors' feet to the fire and say, before I lock this person up, we're gonna do this today?
Yes, in every aspect, I would hold prosecutors' feet to the fire, because the responsibility they bear, the potential impact they can have on a person's life is.
It can be devastating. This woman, she wouldn't eat, she wouldn't shower, she couldn't sleep, she was horrified. It was like the worst experience imaginable for her. And over a case, when I go out there, the DA says, well, we can agree to conditions. This is probably gonna be dismissed for warrant of prosecution, which it was, or quaffed anyway. The same person that filed that motion put this woman in jail for 5 days.
Well, first, as a prosecutor, I apologize to your client on behalf of the community, because
Sorry?
apologize on behalf of the community of prosecutors for what happened to your client.
Well, this.
It's a different place.
It happens all over the place. Is my that's an extreme example. It happened to my client, but it happens all over the place. They file these motions saying we're not ready. You come back 3 days later and they're handing in the police report. We're going on the papers, right? Why can't you do that the first day?
Oh, I agree. That absolutely should be done on the first day. I think it's really important to ask, are we talking about a full hearing? Are we talking about moving on the papers? Do you need a second call to get a 911? Like, what can we do today? I think it's also important to give a little bit of pushback and ask, do we really need to be talking about detention, or can we talk about conditions?
How about good cause? Are you gonna hold their feet to the fire? There's the good cause as to why they need the 3 days.
Absolutely.
Restraining orders.
Yes.
Too many restraining orders issued?
I think they are sometimes abused,
Okay,
both restraining orders and the harassment prevention orders.
yeah. That's a whole nother, that's a statute I don't think ever should have been passed.
There's a whole different ball of wax. I think if restraining orders are a really important safety tool,
Absolutely.
but I do think that they are abused. I think it's really important for judges to pay particular attention in restraining orders because of the balance of the safety risks for the victims, but also there are devastating consequences.
Talking about a civil case here.
Yeah, yes, my experience is often a victim, but I have to balance the public safety interests versus the collateral consequences to the defendant on the restraining order. I, as a judge, would always have to keep, my eyes and my ears open, searching for the credibility. What is the believability, the plausibility of the thing presented before me? Is there corroborating evidence or not? And restraining orders, in my opinion, should only be issued when they're needed, when they meet the statute, when there's credible evidence before me.
Okay. We had a long time to talk in my office the other night, okay? It was kind of a little chaotic, wasn't it?
I thought it was a great window into the life of a solo practitioner. I don't think I could do it.
There may have been a few clients waiting for me while you had to wait.
They were very friendly. We had a great chat.
And I apologize for that wait, but we did spend a lot of time together. You answered a lot of questions for me. I already know you. I know who you are. I know what you're about, and I think you're gonna be an absolutely fantastic judge.
Thank you, sir.
Well said. Thank you, Mr.
Thank you very much.
By
Counselor
the
Dunn.
way, big fan. You impressed them a lot too. You're the person chairing your hearing.
Counselor DePaulo.
Thank you, Mr. Chair. Good afternoon.
Good afternoon, Counselor.
Congrats on your nomination.
Thank you.
I want to start, I didn't have a chance before, but I want to thank your witnesses, both, who kind of offered some strong, courageous testimony. I appreciate that. And I want to start asking you about some of your experience that maybe relates to that. Back when you were in the Child Protection Unit,
Was.
and, you know, one of the things you wrote about doing was coordinating wraparound services, I believe for the victims with the.
The victims and their families.
So from that experience, what have you learned and I know that this experience is played out in the rest of your career, but what did you learn were the needs of folks put in that position?
It's a really complicated situation that you raised, so I think it's great to be able to flesh this out. I think most important thing is to take a holistic approach. My practice was always to put the person before the case, right? So recognizing what do they need, and I was fortunate enough to work with the Children's Advocacy Center, which has these wraparound services all in one location. They had forensic interviewers, SANE nurses, individuals from the Department of Social Services, the children and families. They had social workers. We even had, an organization that helped outfit people with, professional clothing for interviews. So I was really fortunate to have that partnership, not just in helping my victims, but in educating myself about what those needs may be. I've been trained as a lawyer, but not as a public health servant. And so the needs primarily focused around trauma care, mental health needs. There was also a lot of housing and food insecurity that went along with that. And not just for the children, but for the parents and the families, and often extended families based on the cultural situation. The most important thing was to listen and to be there. I firmly believe, and you'll hear me say this over and over again, that these are people and not files. You have to get rid of the aspect of thinking this is a stat or a case. These are real human beings who don't want to be working with you, but kind of have to. And so what is the pace they need to take things out? What do they need?
A couple summers before you started at Suffolk, I interned there in the Child Abuse Division under Judge Deacon and Nancy Hathaway. One thing I noticed there was a couple of the cases that I was able to participate in and observe. The victims, who were children at the time of their victimhood, there were a handful who, in their maturity, found themselves in the court system and in the criminal system. And that kind of, that's not an uncommon occurrence, right, in your experience? And so when I hear you talk about, when I hear anyone talk about a trauma-informed approach or understanding the needs of folks who'd be before you, I sense that you understand those needs. And you talked a little bit about it, but I just want to put a point on it, because the courts are talking about trauma-informed approaches, which is awesome.
Yes.
But it's, similar to in education or any other social service field, that usually the best practice is universal. So treating the courtroom at like a trauma-informed courtroom is not just about finding out, asking questions about a defendant, but it's about just the culture and environment in the courtroom. Sorry for that diversion. You've developed a lot of trainings over the years in your career, and you spoke about a couple of them, and we heard a couple programs mentioned, like restorative justice, for example, was talked about. In terms of your practice now and what you see the landscape of practice in the district courts being, what what is needed? What's the most pressing need as far as content for our practitioners to be trained on? And I don't mean matters of law or developments in the law. I mean, what do you think the practitioners most would benefit, and our courts would most benefit from them being trained in?
So I have a firm belief that most criminal matters stem from a public health issue. Whether that is, or some other sort of systemic failure. Right, because no one is who they are in that one moment they appear there. There's usually some sort of whether it was education, financial resources, mental health, all the things that we've been talking about, counselor. And I think that's the biggest gap, is not just training the practitioners on what is available in their community, but helping them to see the flags, because they're not always obvious. It's not always easy to tell when someone is under the impact of their trauma or their mental health issues or their substance use disorder issues. So teaching people the flags to look for, how to change track so that they can rise to better serve those individuals. And then obviously what's in the community so that they can connect people.
Thank you. I really appreciate throughout your application and your responses so far, and thank you to my colleagues for great questions, your focus on root causes of things and trying to address those as you dispense justice in a fair and equitable manner. Mr. Chair, I have no further questions.
Thank you. Counselor Tara Jacobs.
Thank you. Well, it's good to see you.
Likewise.
We sat down such a long time ago that it was a whole year ago. But no, it's good to see you. And I as much as it was probably about a month ago that we talked, it was a kind of conversation that really stayed with me, and we touched on so many important factors, and then your personal life experiences, your lived experiences that are additive to your resume, just really resonated with me then. And I kind of want to start there, just in terms of, you speak in various places in the application about how those personal lived experiences that you bring to the role inform you on areas like racial bias, other marginalized communities that are impacted in ways in our justice system. And so I'd like to give you an opportunity to philosophically kind of address what you're alluding to throughout the application, but add to that on the bench what impact you can have.
I think you raise a topic that is very obviously near and dear to my heart. I think it's crucial for judges to get to know their community, to get to know the populations of their community and the cultures that exist within those populations. I think it's really important not just to know the community that you serve, but also because based on the cultural sort of preferences of a community, you may have to adjust your approach. I would do my best to get to know the communities that I served, to get to know the resources available, the culture available, to educate myself, to know what's out there. I know what it feels like to be isolated in that way. And I know what it feels like to be made to feel like you are less than. And so it's something that I sincerely hope I would never do to another, and to avoid that, I would make sure to educate myself as much as I could, to ask for help. And if I do err, to apologize and ask how I could do better.
There's two things I want to follow up with you on that. So first, how self-reflective you are and how receptive to feedback you are. Just can you speak to, I guess, your character on that, but just to understand, there's I don't remember if we've talked about it or not, honestly, because it has been a while. But the judgitis thing that can happen, where taking on the robe can lead to a shift in personality. So I wanted you to speak to how you approach hearing, being receptive to and responding to feedback.
Sure. I think, I hope that I never get judgeitis. But I do think it's an excellent thing to prepare for. I know that I am not perfect. No one on this earth is. I know that I have made mistakes and I know that I will in my future make additional mistakes. I greatly appreciate when someone comes to me and says, either I made a mistake or I don't understand why you did that. Can we talk about it? And those have been some of the best learning moments, of not just my professional career, but also for my personal life. So I am open to that feedback and I do often seek it out. Whether I know that I've had an off day or I'm not sure I did something right or I catch my own mistakes. I think it's really important to self-reflect and to be open to feedback. Particularly, it's not always easy for people to come and say, I think you messed up. So you've got to be kind and you've got to be open. And, I have had some experience with this, supervising the 1 district court that Suffolk has and the 8 municipal courts, and then in Plymouth County, 4 district courts. I won't claim that I was perfect. I was often running around like a woman with my hair on fire, trying to figure everything out. So I made mistakes and I had, great attorneys, advocates, admins that say like, hey, I think we need to correct an issue. So I've always been thankful. I've always accepted that feedback. And, I anticipate no one is perfect. It will happen again.
Well, so I think there's probably multiple things that contribute to the whole judgeitis phenomenon. And some are very much a personal thing, but I think a big part of it is that, people respond differently to the authority of the role. And so the feedback may come less frequently or not at all.
You're absolutely
But I do think there's probably an approach that can create a safe avenue for that kind of feedback if it's intentional. And that actually leads me to a different next question about a sort of safe space, but thinking about district court, thinking about BMC, thinking about the trauma that does, what has led to someone in the room. I'd like to hear your thoughts about creating or contributing to a safe space in which someone who is actively in a trauma response can contribute to their case in a way that is not further triggering, further harmful.
I think there's actually 2 aspects to that. One is the community of people who work within the courthouse who are exposed day in and day out to trauma. And then there's the litigants. In terms of those working within the courthouse, I've always had an open door policy, and I have not always, I had to learn some hard ways myself to prioritize attorney well-being and work-life balance. And I then made it a priority to teach those skills as best I could to the people that I worked with. To be a safe person that they could go to when they were struggling, to also go to someone and say, quietly, privately, but I think you may be struggling. Is there something I can do? Do you need to take some time off? Do you want to talk about something? So I think there's that aspect, the courthouse employees. So having an open door policy, publicizing that I am someone who prioritizes that, which I think helps take away some of the stigma of it, which is really important to do, and knowing that people can come to me. And then in terms of the in-session trauma responses, like I alluded to before, just making sure that I stay up to date on trauma-informed practices, what to look for, what suggestions to make, quietly calling attorneys to sidebar to say, is something going on that we need to be mindful of? We need to adjust course. Does your client need for us to call the case later? If there's a victim there to make an impact statement, do we need to clear the courtroom? So just being mindful, but also being open to the suggestions of the attorneys that are working with the individuals involved, because they're going to have better input. Right? And you need to rely on the expertise of others when it's something you're shortcoming.
I appreciate that. Do I still have time for one more question?
That's it.
Time for one more question, or if I?
One more.
One more?
Yeah.
Okay. It just leads me to a follow-up question, which is, I would imagine not only relegated to the communities that I represent, but probably relevant across the state, but, in our communities that have very high need, population where, there's food insecurity, there's housing insecurity, there's, just economic stress and struggle where, you know, potentially you see this person wearing the same clothes every day because that's the clothes they have. You know, they may not be, you know, on a day like today, they might be wearing shorts because that's what they've got. And show up in court wearing whatever it might be that they're wearing that might seem to be reflective of a lack of respect, but in reality are the economic situation of that person. The choices are not broad. I have seen judges bristle at what is perceived as disrespect from that sort of a thing. And so, you know, I'm curious about your thoughts about how you, sitting on the bench when faced with someone who might seem improperly dressed for court or acting in a way that is seemingly not respectful for court, which could be a trauma response or cultural or what have you. You know, how you think you would from the bench handle that.
So I think, you know, there is this interesting overlap between, is this trauma? Is this what they have? What are the assumptions and biases that I may have as a woman coming from a different economic position, a different education position? I have two sort of philosophies in this area. One is that I truly believe everyone I interact with is doing the best they can with what they have, but particularly in the court system, most people don't have enough of what they need. And I also believe firmly in, which can be hard, it's something that I think everyone needs to constantly check themselves on, but don't fill in the gaps in your knowledge with assumptions based on your own beliefs and experiences, because they're not the same as anyone else's. Every single person in this room has had a different life, a different realm of experiences, and that impacts who you are, how you present yourself. It can be really easy to fill in the gaps with assumptions. And so keeping in mind that I assume everyone is doing the best they can with what they have, if we're teetering into what I think may be disrespectful, pause and ask questions. It could be trauma. It could be that this is what they have. It could be that they've never been to court before and they had no idea what to expect. They had no idea of what was expected of them. And that's okay. So just keeping those two philosophies in mind.
Very much appreciate that answer. Thank you very much for this time.
Before I go to me, just want a quick follow-up on that.
Absolutely.
Is there anything, somebody comes, you know, before you in court, and which a reasonable person may infer that the attire, the T-shirt was inappropriate? Okay, the language on the T-shirt, following up on her question, is there any, would that bother you, or what are your thoughts on that?
I think
Language on the T-shirt.
yeah, and I have seen that in court, and I've seen judges respond to it in different ways. I also think it's possible for people to make honest mistakes. I would most likely call the attorneys up to sidebar and say something along the lines of, I've noticed the language on your, on so-and-so shirt. Did they realize what they chose to wear today when they came here? We possibly ask them, without making any sort of a fuss about it, but to put the shirt inside out. A second call. I've seen judges do that. You know, I don't want to accidentally shame someone who just made an honest mistake. A lot of people don't know what to expect in court. They don't know what's expected of them. I agree, sometimes the language is questionable on the clothing that I've seen in court, and that may be my assumption. They should have known better. So I don't want to make an assumption, a negative assumption about someone. I would ask their attorney, and perhaps the attorney could step the case back, have a second call, talk to their client in the hallway, have the T-shirt turned inside out, sweatshirt, have you.
That's a really good answer. I've asked that before and people wiggle around. I like the answer. Good answer. Counselor Civil.
Sir, how are you?
Wonderful. How are you?
Good. Congratulations on your nominee.
Congratulations on your election and to all the new counselors.
Thank you. I know that you've been practicing for more than 20 years. And I know that you were a prosecutor, DA's office, where I was also working, but we didn't work together as a victim witness advocate. And I know how dealing with domestic violence, sexual assault, and trafficking with victims, how difficult it can be sometimes, especially those who are worried about their immigration status or afraid of losing their children, or sometimes when they're not willing to testify, a warrant may be issued. I want to know and ask what actions would you take, given an opportunity to be an associate judge, take to enhance the safety and protection of the victims in our legal system?
You know, you raised something that sort of hits on a really large part of my practice. I've done a lot of victim work, domestic violence, child sexual assaults, and firearm related in our communities. I've seen all kinds of responses. And I've seen, you know, particularly women and particularly women of color being forced to make these impossible decisions. Do they stay with their abuser because the lease is in their name? They're stay-at-home mom, no financial security. So I think it's really important to keep in mind all of the factors that may cause a victim to appear a certain way in court, to take a certain position of the case. I think it all goes back to that trauma-informed, culturally competent way of approaching cases. So I would make sure to do that. I would also make sure to be fully aware of the resources for victims in the community and in the larger community. Each community is not going to have everything that you need, but work very closely with the probation department. I think they usually have tremendous resources, as well as the social workers assigned to any of the specialty court services, to learn a little bit more about what is available, and not just what's available, but what's good, because not every program is going to meet every need. So I'd make sure to educate myself so that I could know, so that if I caught something within the facts of a case or saw some trauma-driven behavior in the courthouse, I could, you know, I can't practice, I can't tip my thumb on the scale, but I can make suggestions to attorneys. You know, have you thought about this as either a pre-trial service? And we have a victim witness advocate in the courtroom. Has anyone spoken to this individual about restraining orders, about their rights, about the shelter services in the community? So being aware, speaking up with what is appropriate within the limits of a judge.
And my second question would be restraining orders. I know one of my colleagues, I had asked you before. We know that prosecutors can be very victim driven. We know that sometimes victims may not want to may get a restraining order today, but tomorrow come and remove the restraining order. What would you do? Would you be willing to, if a victim comes in but doesn't have substantial evidence to issue to get a restraining order, and it's just enough is not there, would you be willing to do a two-party hearing just to make sure that this victim or a person who's coming in is still being heard and is knowing that the court wants them to be protected, but also know that we are here to service them? Are you willing to do a two-party hearing? Because we know that restraining orders, once they get on your record, it doesn't go away. And sometimes people come in and request for a restraining order on an individual who has no records. So would you be willing to do a two-party hearing to allow this person to know that you're here to listen to them and you're not pushing them away and you're willing to have them come back for a hearing?
Yes, and I also think, if I may follow up sort of a little bit on what you asked, on another aspect of what I would do is, I think judges serve a crucial role in educating both, not just victims, but the community and also police officers. So to the extent someone came before me in a restraining order and I felt like there wasn't enough, I think it's really important for judges to explain, this is the law, this is what you presented, and this is what I see is not enough, so I cannot issue it. You know, court is often, you know, it can be a completely foreign language to a lot of people, and I think it can be really easy for everyone working in the courthouse to forget that, and to forget that, you know, these people haven't studied the law, or they haven't been working with, as a VWA, helping people get restraining orders. They haven't been working in the probation department, BOPs for people, Board of Probation Records. So I think it's really important to remember that and to help the public understand why something either is or is not happening.
And my last question would be, I know you have the professional experience and also the lived experience. I know how much your family means a lot to you. I know your father was a former police officer. What has that taught you being in the legal system, and how do you tend to bring that or use that as an experience of when people are coming in from the community who has experience being, you know, misjudged by police, or just being able, not having a good experience with the law enforcement? What would you say, or what would you bring to the table as a judge, knowing that, you know, there are some good police officers, not all of them are bad, but what can you bring to the table, given the fact that you've experienced someone that you love dearly to the forefront when you become a judge?
You know, I think one thing that may, you know, my father was not just a police officer, he was a Black police officer in Massachusetts, and spent a lot of his time working in Boston, in a partnership with the Boston Police Department, the MBTA, the DEA. That is not a diverse world. And he has seen, and we have talked about, you know, growing up as a child, talking about the good and the bad that police can do, the good and the bad impact they can have on people, and the importance of standing up and speaking out when something is wrong. And I carried that forward into my career as a prosecutor. You know, one of the jobs of the prosecutor, you have this tremendous responsibility in deciding what cases are brought and how, what charges. And so I have always tried to ask as many questions as I possibly could so that I could understand. I have always been very clear when I thought the police did not have it. You don't have it in the search warrant. You don't have it in this case. I'm not going to indict it as that. I'm not going to keep the mandatory minimum, and this is why. But I've also been someone to say, I don't understand what you've given me. This is what I think is missing. Can you help me understand? Is there something that's truly not here? Is there something that is, but for some reason you didn't put it in before me? And if so, why? So I think it's really important as a judge to keep in mind all of those things, that there are good actors and bad actors. You need to ask questions. You need to have a practical approach and a logical approach. Just, does this make sense in front of me? And to push back where pushback is needed. And then to the extent a community member was complaining about something that happened, I think you have to take all those complaints seriously. Some of them are going to have merit and some of them are not. Some of them are going to be just a difference of opinion. But as a judge, I would have an obligation to explore that because there are constitutional rights, there's safety, there's personal, you know, this personal sense of safety in your community is really important. And in some ways, having that violated can feel like the worst violation there is. So it's very mindful to be aware of all of that and to question it when you see something is off.
Thank you. No further questions.
Thank you, Councilor Dolan.
Thank you so much. Attorney Pierce, I really enjoyed speaking with you earlier this week, and I appreciated getting the opportunity to get to know you better and to hear your perspective, particularly because I come from a defense background and you've been a prosecutor.
Correct.
And you worked for State Street Bank.
Yes.
So based on everything that I've been privileged to hear from talking with you, listening to your testimony today, reading your application, I know that there's more to you than that. But for those people who haven't had that opportunity, what do you say to them when they say you've only been a prosecutor and worked for State Street Bank? You've only represented the more powerful. How can you really be a fair judge? What do you say to those folks?
You know, it is a great question. I'm kind of surprised it hasn't brought up earlier that no one has said we've only been a prosecutor. I think it can be easy to forget how much work prosecutors do with victims and with community members who have been impacted by crime. I have gone to community meetings, I've spoken in public schools, I have worked with people who've had their voices stolen from them. Done a lot of work with the communities living in some of Boston's sort of really tougher public housing. I recall, you know, one case I had where the deceased was discovered, you know, the people in the building refused to use the stairwells because of the activities that were happening in the stairwells, and then the elevator broke, and that's how my case came to light. And so remembering, you know, all of that experience while I was a prosecutor and I did have that position of power, it was all to help people who didn't. It was all to help people who didn't have a voice or whose voice was stolen, who were impacted by things in their community that they had no choice over, that, you know, really had tremendous consequences on their everyday lives in such a negative way, and doing something to help those people in a system that, you know, sometimes they didn't have a role in. How does a community member impacted by the drugs being used in their building, how do they come into the courthouse for help? Does it maybe look like a trespassing case that people don't take seriously, but for that community of people is really actually very important. And so I've done a lot of work, I think my entire career as a prosecutor in that genre. On a personal level, I've also done a lot of volunteering. I cook once a month for a community member that's randomly assigned to me, and I always listen to their stories. Stories of people in need going through really tough circumstances. I spent many years volunteering at an animal shelter, specifically in their food bank, helping to ensure that the people who needed, quite frankly, they were at such unstable places. They were close to surrendering their pet, their loved one, because they didn't have food. So I've made it a part of both my personal and my professional life.
Thank you. One of the issues that you raised when you spoke is how hard and overworked a lot of people in our courts are, from prosecutors, defense attorneys, probation officers, court officers who maintain order and make sure that we stay safe. You said they're doing the best they can with what they have, but they don't have enough. And I asked you if you would apply that view to the people who appear before you. Can you tell us what you said?
I think that philosophy applies to everyone. You know, the vast majority of people who are going through the court system don't want to be there. Mm-hmm. And they're there because of a lifetime of events. And those events may be systemic failures. They may be trauma that has occurred to them. And those people too are doing the best they can with what they have, but they don't have enough. And I think it's really important to keep that in mind. There are very few actors in the criminal justice system who are bad actors. Very, very few. Most of them are just, quite frankly, struggling.
That's my view. That is my view, and I really appreciate that. And I wanted to ask you about your view of alcohol use and substance use disorder. As I shared with you, my sister died from an alcohol use disorder. So both as a professional and personally, I am extremely well acquainted with the dynamics of alcohol use and substance use disorder. And I have appeared before a number of judges who believe that they can punish people into recovery, that if they just inflict enough suffering on them, they will see the light and they will embrace recovery. It's not true. If suffering cured addiction, no one would have one. Alcohol use and substance use disorders are a chronic, recurring condition of the brain that does not respond to negative consequences. What is your view, and how will you apply that view as a judge to people who appear before you who have an alcohol use or substance use disorder, or both?
I think alcohol and substance use disorder are a health issue. And I think there can be many drivers to that. It can be a genetic. It can be, something traumatic happened in their life. It can be they had an injury and things got away from them. But at the end of the day, it's a health issue. I also, which means we need expertise beyond that, which most people working in the court system have. We need doctors, we need nurses, we need clinicians, we need mental health services. So I think it's really important to always remember this is a health issue and that I am not qualified to treat a health issue, but I can connect myself and my courthouse to the people who are and take full advantage of those. So I think that's one thing. I also think I disagree that shaming anyone or punishing anyone or their health issue we wouldn't punish someone with cancer. And I think it actually does more harm because we're sort of stigmatizing something that's a health issue. You wouldn't stigmatize someone who had cancer. You wouldn't yell at them. You wouldn't incarcerate them for it. We need to take it for the health issue that it is. I also think it's really important that when someone makes positive steps in their recovery, that is celebrated and lifted up. And that if they have a relapse, there is no shame, there is no stigma, there is no yelling. You identify, okay, you know, what do we think led to the relapse? And how do we better equip you to deal with it in the future?
Exactly. Thank you so much. And we really need judges who understand that as well as you clearly do. I just have one more question. We heard this morning from a public defender, Attorney Connor Barouch, and I asked Attorney Barouch about the coming changes to Rule 14 of the Massachusetts Rules of Criminal Procedure, which govern disclosure of what prosecutors are required to turn over, and the change that the Supreme Judicial Court has made in no longer referring to it as exculpatory evidence, but referring to it as evidence favorable to the defense and listing 19 different categories. And as I said to Attorney Barouch and said to you, Mass Lawyers Weekly did a story saying that defense attorneys think that judges are really going to have to be tough with prosecutors to make sure that there is timely compliance with Rule 14. Do you think that's true? What's your view, and are you prepared to do it if necessary?
I'm prepared to do it if necessary. I think prosecutors should hold their own feet to the fire. I think they have, you know, as I've alluded to, they have tremendous power, they have tremendous responsibility. The work they do has huge impacts on people's lives. The burden of proof is on the should be, and the litigation should be fair. I have always had an open file policy. I have been trained to do that. That was how I trained the people who came after me. So I think there are great aspects of the new Rule 14. Yeah, I would love for it to be broad. I mean, honestly, I just think if you have something in your file, whether you intend to introduce it or not, it should be turned over. The defendant should have everything. Should have everything that Paul has minus work product. And so I like the changes. I do think they clarify what is exculpatory by sort of removing the ability to make that a subjective determination, because I think that invites error. I like that it is talk about my nerd and my love of sort of like writing and proofreading. I like being organized and much clearer. And when a statute is clearer, it increases the odds of compliance, particularly when you're dealing with, you know, most district and municipal court lawyers have less than 2 or 3 years practice under their belts, and they have tremendously huge caseloads. So the simpler we can make things, the more we can increase compliance. The mistakes will be made. And like I said, there is always the potential for a bad actor. But yes, I would hold their feet to the fire. I do like the changes in the rule.
Thank you. And I just want to say, in conclusion, just as Counselor Kennedy was complimentary of the new counselors in our questions today, I'd like to thank the more experienced counselors for their questions. It's been great to be last because I get to hear everybody's questions first. And I also just want to let you know that Counselor Ionel has been very highly of you. So thank you.
Thank you very much. I don't have many questions. I appreciate Counselor Dolan's question to you about alcoholism and drug addiction. And I really liked, again, your answer. Too many times, I very rarely, almost never go to court. I used to go all the time, way back when. but I recall many, many years ago, if a defendant violated the terms of probation, the probation officer would violate them. And too many times, way too many times, the judge would say, okay, you're in violation of the terms of your probation, and we're gonna send you, 6 months to the House of Correction. You know what, as you said, to be successful when dealing with drugs and alcoholism, you're gonna fail. You're gonna fail on the way. So that to me is fine, okay? But I like the fact that you realize that and you'll give people second and third chances. Because in order to be successful, at least I think, there may be many, and I don't know about many, but there's gonna be occasions when you slip up, when you fail. So I do really like your answer.
Thank you.
The last thing, I love it when the parents are here. Oftentimes, the parents are not able to be here many times because of the nominee's age. So that's great. I mean,
Any other way?
yeah, you're a Boston police officer? What's that?
State police.
Oh, state police, yeah. Okay, yeah. And what a proud day. Proud day. I remember way back when I got elected to the Governor's Council, my father used to tell me that was one of the proudest days of his life when we got sworn in the House chamber and he was at the end of the chamber and he looked at me. I know how proud he was. So yeah, your folks, your family, it's a proud day. We have a unique day today. What do I mean by that? Jamaica Plain, Connor Barouch, Jamaica Plain. Guess what? Jamaica Plain. So we're all Jamaica Plain. I love Jamaica Plain. There's no place I'd rather live than Jamaica Plain. It's got so much to offer. I love it. And I love the fact that you live in Jamaica Plain. You go into the Boston Municipal Court. I'm a strong believer I love to have people get involved with and be nominated to the court because the district court, the Boston Municipal Court, it's a community court. Okay, oftentimes you'll have somebody from, Concord sitting in the Boston Municipal Court. I like people in the community. I'm fully behind your nomination. And when your name comes up next week, I'll be more than happy to vote for you. And one last thing. I talked to Kennedy. I said, this lady's really nice. He says, yeah, I looked at her resume. I like her too. So he gets a little credit too. So thank you. I know you folks have all been patient, but it's a great day. And next week we'll vote on your nomination. Thank you.